to mention for the appellant, it was fixed matter 17th August 2026, but that day was not to pass any adverse order, mentioning for to be mentioned.
Anyway, yes.
A similar prayer, your lordship, by an order dated 30th June 2026, the second appeal was fixed on 16th July at 3. But therefore, my lord, it was never taken, your lordship. If your lordship kindly keep it to be mentioned.
Anyway, let it appear as to be mentioned. Thereafter, it will be fixed.
Yes, my lord. My lord, it was already mentioned before as well, my lord. It has appeared.
Anyway, on the to be mentioned date, it will be taken up.
Yes, sir. May I be permitted
Yes.
to mention section 5 application, my lord. Execution proceeding has been started, my lord.
Yes. Serve notice upon the other side.
My lord, in the meantime,
Copy of the application. Yes.
One matter lordship has fixed at 1 o'clock today, my lord. If that has not come in the list, my lord, perhaps, my lord, it is coming in the supplementary list.
1 o'clock.
Yes.
Okay.
It was.
It will appear in the supplementary list.
I've heard from the.
Intimate the other side.
My lord, other side, I have served them that matter will come today. I have affidavit service. I will place the that.
But today it is not appearing in the list.
But my lord, other side, I have served the client. It is in Durgapur. I have served by email.
Okay. Nobody is representing.
No.
Hello, diye the supplementary list. কোনটা আছে ও with the list না inside okay হ্যাঁ yes
inside the list, my lord. My lord, item number 30 of today's list, my lord. Yesterday, my lord, I have mentioned the matter before your lordship that your lordship has directed the matter to be appear as today, my lord. But to be mentioned matter
No,
will not be taken up today.
no the question is what is to be done in this matter?
My lord, only stay application, my lord. Only usual stay order, my lord. Execution case has been filed before the learned tribunal. Anytime, my lord, kindly take it up, my lord. Only it will take only 1 month, my lord. Usual stay order, my lord.
Item 30.
To be mentioned, Judge.
No, here there is no other side is not there.
Mr. Mondal is Joyanta Mondal
Oh,
is there.
so bring him.
Yes. Any.
So bring him there. Then only I'll take it up at 2 p.m.
Very well, my lord. Or before rising, my lord.
Yes, anyway, you bring him, okay?
Yes,
Because
Your lordship, may I be permitted to mention item number 109, your lordship. It's a section 5 application in a second appeal, your lordship. If your lordship may kindly takes it up, keeps it in to be mentioned, your lordship.
no, which one is section 5? Can one?
Can one.
So what is the urgency?
Lordship, they're trying to dispossess us. It's a suit for recovery of possession, your lordship. They're trying to dispossess us.
109. Yes, tomorrow it will appear under the same heading. আচ্ছা এটাকে ইয়ে করে দেবেন তো একটু হ্যাঁ হ্যাঁ ওটাকে ইয়েতে দিয়ে দেবেন টপিক
Having consent of my learned friend, my lord, appearing for the applicant, my lord, I am praying only not today.
which
Item
item?
number 89.
89. 89. Okay, not this week.
Your lordship, next time.
My lord, for the respondent.
Yes, give the records.
এখানে 411
হ্যাঁ
Congratulations to my lord.
Thank you.
তোমারটা দাও না, এটা দিন, এটা দাও না মাই লর্ড, দেখুন।
My lord, paragraph number 19 and 20. The final judgment arrived at 23,50,000, but the paragraph number 19, it is written 25,50,000. That should be 23,50,000.
And this interest portion not mentioned.
Not mentioned.
So here, para 19, para 20.
19, para 20. Other parts are remain the same.
Yes, record and order. So para 20 mentions about interest.
Yes, yes.
So it is not necessary. Only this quantum is to be altered.
Quantum is to be.
Learned advocates for the parties are present. The matter is put up for necessary rectification of judgment and order dated 13/8/2026. In paragraph 19 of the said judgment and order, instead of 25,50,000 mentioned in 10th line of para 19, it should be recorded as 23,50,000. Stop. Similarly, in paragraph 20 also, in the second line, instead of rupees 25,50,000, it shall be mentioned rupees 23,50,000. Other contents of the order, let the rectifications be carried out. Other contents of the order remain unaltered.
Grateful, my lord.
Yes. 87. Okay. Not today.
Yeah, 18, may I pray for not this week, my lord?
Not this week. Grateful to your lordship.
90.
Yes.
91.
For the applicant.
My lord, I am appearing on behalf of the respondent, my lord. My lord, only one humble submission before the taking the matter, my lord. Can the liberty to given to file the opposition of Can 5, my lord?
Can
No, no.
5.
Yes.
Can
Lord,
5
there
is
is
not
one
appearing.
Yes, my lord.
91 item.
Yes, my lord.
Item, yes, my lord.
Can 5 is not a Can 5 is for what?
For substitution of the proposed respondent. My lord, kindly have a look at the earlier order when my learned friend appeared and submitted before this court that one of the proposed respondent, one of his clients had died, and he has given me the photocopy of death certificate. I have filed Can 5, filing slip is with me. I have also served copy upon all the proposed respondents. Now the difficulty is Can 5 is not appearing in the list, and compute in the computer it is not also showing, but I have the copy and I have served
Yes, my
it,
lord.
and this is the filing slip.
So this is the substitution application.
Yes, substitution.
So
Up-
are you opposing this
Yes, my lord.
application?
Time, there is a limitation, my lord.
After
Oh, on that ground you are opposing.
Yes, my lord.
Very well, file your opposition. Is there any interim order?
No, my lord.
No question of any interim order.
No.
one thing, subject to approval of my learned friend, can 5 photocopy of Can 5 be taken into record, or it can be reconstituted?
I shall fix a date. I'll grant him opportunity to file opposition and you to file the reply. Let it appear on a particular date. On that date, if the matter is not listed, you give your copy. Yes, record an order. Learned advocates for the, you're for all the respondents.
I have my lord.
Learned advocate for the appellant and learned advocate for the respondent number 1 are present. Let application Can 5 of 2025 be listed on 15/9/2026. The affidavit in opposition may be filed by 2/9/2026. Reply, if any, by 11/9/2026. Grateful.
Where I'm praying for not today, madam.
Which item?
92.
Okay, 92, not this week. Grateful.
93, I am for the respondent.
93, you are for the respondent.
Applicant, Lordship, I'm paying some time, my lord.
Not this week.
Grateful. Lordship, I am for the petitioner. It's a Can 2 application for the extension of interim order. The order has been passed on 5th February 2024.
Paper books are ready. Yes, record an order.
Lordship, this is the affidavit of service.
What is that?
Affidavit of service.
Okay. Record an order. Learned advocate for the appellant is present. The affidavit of service filed be kept with the record. The application for extension. Dekhi, application take 2. Application for extension of time, extension of interim order being Can 2 of 2026 is taken up for consideration. Yes, you are
I'm for
appealing.
the respondent.
So paper books are ready.
No, paper books are ready. Paper books are not ready.
You are for all the respondents.
Yes.
The interim order granted earlier stands extended for a period of 6 weeks. The paper book, the informal, the trial court records have come. Trial court records is check.
Trial court records have come.
Okay.
They need to
The
prepare.
informal paper books be prepared within 5 weeks and copy be served. Let this matter appear after 5 weeks.
Identified.
95, my lord, I'm led by Mr. Chittapriya Ghosh, my lord. On the last occasion, there was a direction that the respondent will file their affidavits. My lord, till date, they have not filed, nor they have served a copy to us. Kindly see my lord's last order, my lord.
Let me see
Section-
which application you are moving.
5 application.
Section 5. Let me see.
Kindly direct them to serve us and fixed a date for hearing, my lord.
देखिए order टा देखिए last order टा. Okay, they have not appeared also.
Last occasion, my lord, they have appeared, my lord. Today they have.
The record and order. Learned advocate for the appellant is present. None appears for the respondents. However, in the interest of justice, the matter stands adjourned till
Fix.
10/9/2026. The affidavit in opposition, if any. Acha, the affidavits must be exchanged in the meantime.
Text.
26. Your Lordship, in this matter, I am appearing on behalf of the respondent applicant.
What application?
We took out an application for repairing of a door.
Item?
Item number 96.
Did I pass any order in this matter?
Your Lordship passed an order.
Probably I passed an order.
Your Lordship.
So, as per that said order, the special officer is to submit a report.
Yes,
So, what
Your
happened to that?
But Your Lordship, the learned special officer
Okay, let
has
me
some
see.
personal difficulty.
Okay.
He will not be able to.
Anyway, I'm passing an order making some alternate arrangements.
Gratefully.
Yes, record an order. Learned advocates for the respondent's applicant is present. It is submitted by the learned advocate appearing for the respondent's applicants that in terms of earlier order dated 8/7/2026, learned special officer could not take any steps and is not willing to do the inspection work due to some personal difficulties. In the facts and circumstances, the matter stands adjourned till 15/9/2026. The learned special officer in the instant case shall be, yes, Mrs. Paul, please give your phone number. Okay, in this you are appointed as special officer. Ms. Sucharita Pal is appointed as special officer in place and state of Mr. Kajol Roy. Miss Ms. Sucharita Pal, learned advocate, phone number, total number ta likhe neben. The learned special officer shall take steps in terms of order dated 8/7/2026 and pass report on 15/9/2026. 15/9 is the date.
My lord, item number 97, I beg to appear on behalf of the appellant, my lord. I'm praying for not today.
Okay, not this week.
97 probably I am appearing on behalf of the appellant.
So,
97,
yes.
Madhumita Sharnal. I am for the respondent number 123. I don't know who is appearing for the.
My lord, Pakar stand 98, my lord. I stand
Okay, 97, you are for the appellant.
I am for the appellant, my lord.
Yes.
Chief, on the last occasion when this matter was taken up, my lord, it was fixed for hearing because the applications that they have filed will ultimately decide the appeal itself. Paper books has been filed, my lord, LCR has been.
So let this matter appear for hearing, second appeal. Yes, learned advocates for the parties are present. As the paper books are ready, let the paper books be filed.
No,
Then-
my lord,
No,
paper
or-
books has
Oh,
been
paper
filed.
books are already filed. Let this matter
And LCR is also.
appear for hearing on 17/9/2026. এই 17 তারিখে দেখুন তো টাইমিংসটা একটু।
One application is pending that is for additional evidence, my lord. This
That
application
has to be taken along with the appeal.
along with the appellant.
Everything.
Whether
That
it
should be
is
heard along
necessary
with
or
the
not.
appellant.
17/9/2026 at 3 p.m.
Lordship.
98, my lord. Kindly mix it not today, my lord. I'm for the appellant.
Okay, not today.
Grateful, my lord.
99.
My lord, I'm for the appellant, lordship. I'm praying for not today, lordship.
Okay, not this week.
Grateful, lordship.
100.
But I appear for the Millard respondent. Millard, there was a special officer appointed. Millard, no report has been circulated to us.
Let me see.
Service of the court, how can I?
So report is circulated.
No,
Report is not circulated. Report is being filed today. So let the report be circulated. If you want to take exception to the report, you take exceptions. Okay. Record and order. Learned advocate for the. You are for the respondent, Mr. Bhattacharya. Learned advocate for the respondent is present. The learned special officer is present today and has filed the report. Let the report be circulated. Exceptions, if any, to the said report may be taken on or before 11/9/2026. Let this matter appear on. দেখুন কবে আছে এটা তো অ্যাপ্লিকেশনে থাকবে আর কি। Let this matter appear on 15/9/2026.
My lord, I am.
Yes.
Report
You want 16 September?
Next week, Millard, kindly takes it up next week.
No, next week this bench may not sit due to circuit.
Oh,
My lord, I am for the appellant. Let a
Learned
copy of
advocates for the parties are present. Yes, circulate the report.
Letter and my lord may kindly give me an opportunity to use an exception to it.
I have
not
recorded
seen-
that. I passed an.
I was not there. I'm so grateful.
Yes, let a further remuneration of 100 GMs each, 100 GMs, be 100 GMs each to be, sorry, let us further remuneration of 200 GMs each to be shared equally by the parties be paid to the learned special officer.
My lord has kept it on
16th, Lordship.
16th, yes.
16th, Lordship.
Yes, 16th of September.
16th of September.
So whatever you want to take, you take in the meantime.
In the meantime, if I were to use any
So necessary orders are to be passed on that day.
I'm grateful. I'm grateful.
101. Lordship, I am for the applicant. Section 5 application, Lordship, last option in Lordship, director served. All are served, my lord.
Degi, record. So service is complete. Yes. How many days delay?
Permission has been.
Can 2.
181, Lordship. Yes, and number 2. And 1.
Yes, record an order. Learned advocate for the appellant is present. You have served all the respondents. None appears for the respondents in spite of service of notice. The affidavit of service file be kept with the record. The petitioner appellant has filed this application for condonation of delay in preferring this appeal. It is the contention of the appellant petitioners that although the appellant petitioners have pursued their suit with full diligence and sincerity, lastly, when the matter was taken up by the learned appellate court, the petitioners were not duly informed by the clerk of the learned advocate of the appellants, and they were told that judgment will be passed subsequently. Thereafter, after a long period, the appellants came to know about the judgment and order passed by the learned first appellate court. In the facts and circumstances, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned. Can 2 of 2026 stands disposed. Let this matter be placed before the Honorable Division Bench, having determination in the matter for the purpose of admission.
Can 1, my lord.
Oh, the can 1 of 2026, can 1 of 2026 stands disposed. Let the matter be placed before the Honorable Division Bench, having determination in the matter for the purpose of admission. So can 1 করে দেবেন আর can 2 এর জায়গায় can 1 করে দেবেন না না can 2 টা থাকছে আর কি can 2 is for what stay
Injunction application.
okay can 2
My lord,
can 1
yes, my lord's kind leave to mention item number 87. My lord, I tender my apology. I could not be present at that point of time. I was rushing from another court. I'm for respondent number 1 and 2.
You are for
respondent number 1 and 2.
Anyway, other side is not there. Let it be not today.
Your lordship, they are enjoying the injunction.
Anyway, what can be done when the matter was called? You were not there. Anyway, come next week.
Deeply obliged, man.
My lord, before my lord, item 30, Mr. Mondal is.
Yes, item
30. 30.
Yes, item call item 30. It is what for correction?
Not correction, but stay application.
My lord, this matter was running under the heading hearing, my lord.
Wrongly, my lord, well, stay was not moved yet, my lord.
No, not wrongly, my lord, there was order. There was order. Paper book has been filed.
This, my lord.
My lord, in this case, my lord, insurance company, my lord.
Yes,
stay
দেখি রেকর্ডটা একটু
Rama Mujumdar.
Rama Mujumdar.
United India Insurance Company versus Rama Mujumdar.
Application and give it.
The application touch है.
Application number 1 of 25. Act of the
पाओ जाचे.
Yes. Learned advocate for the appellant and learned advocate for the claimant's respondents are present.
Paper book has been filed.
The application for stay is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 10 January 2023, passed by learned Judge, Special Court, cum Additional District Judge Durgapur, Paschim Bardhaman, in MSC case number 96 of 2014 for a period of 5 weeks. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of the appeal. The registrar ota kore deben. Registrar General is requested to invest the ota jeta format ache. As respondents number 1 and 2 have entered appearance, service of notice upon respondents number 1 and 2 be dispensed with. So vehicle owner?
No, dispense, maybe
Okay.
dispensed with.
The service of notice upon the respondent number 3 is also dispensed with. Stop. So is it only challenge with regard to quantum? Okay. As there is a chance of settlement in this matter, the matter is referred to the Honorable Lok Adalat to be held in the month of September. Fixed 17/9/2026 for report of the Honorable Lok Adalat and further orders.
Your Lordship said, entire awarded sum together with interest for less statutory amount.
No, it is implied.
No, kindly, otherwise, it will take get problem.
See,
Less
in all cases, acha, okay, including interest, excluding statutory, the appellant insurance company shall deposit the awarded sum along with the interest as directed by the learned trial court, excluding the statutory amount.
There is also cross objection. That is
in the list. That is in the list.
So take your chance before Lok Adalat. Thereafter, I shall see.
Well, grateful to us.
I am tendering my unqualified apology with regard to item 96. Due to traffic jam, I could not come before your lordship.
No, what you
I am for the appellant. I am told some of the special officer has been changed.
Yes, because this 96 matter, there was a direction.
Yes.
Mr.
Kajol
yes. That is why the learned advocate submitted that due to certain difficulties, he is unable to do the inspection work. I have appointed a substitute special officer. Okay, go through the order. And a date of report is also fixed on 15/9.
15/9. And one thing, I am praying, let the appeal be fixed with this matter.
Okay,
Appeal
because
be heard out. Otherwise,
this bench may not sit for 2 weeks due to circuit. So come on 17th, 15th.
15th,
Within a few days I shall fix.
Let the appeal be also fixed, heard out.
I shall fix
They
it.
are not
No, if the
eager to
if the
make
paper
the
books are ready, the appeal can be. If the paper books are ready, the appeal can be fixed within few days.
Paper book has already been filed.
If the paper books are ready, within 1 or 2 days, the appeal will be fixed. Thereafter.
But my name be recorded.
Yes, his name be recorded.
The next order, item number 5 and 6.
Read, yeah. For the appellant. I am for the appellant.
What is the ground of challenge? Quantum?
No, income. Income?
No. The question is, if it is quantum, then go to the Lok Adalat.
Income.
No. Income that is also quantum.
I have also cross objection.
That is also quantum.
Deduction.
Your Lordship has on the last
Ultimately,
occasion, Your Lordship was pleased to directly
ultimately it is
provide a
quantum.
note of argument. We have prepared one.
Oh, the matter is hard already. Acha, have you filed your written notes?
Yes, Your Lordship is on the last occasion could not. I am ready with that.
No, no, written notes. Acha.
কথা বলছি।
Okay, cross objection is yours.
Yes.
That,
Okay. According
yes,
to
what is the ground of challenge?
my ground of challenge, Your Lordship kindly come to the page 44 award
Page
of the paper.
44.
Starts from page 40, so currently straight will come to page 44. This is the award under challenge. I have proved by the appellant proved the income of the deceased by adducing evidence of the employer. Even then, the learned court below hold that he is not entitled to get the same and fix the income notionally 5,000 instead of 9,000. This is the sum and substance of the appeal.
Okay, just page 44.
It starts from page 44.
Yes, what is the relevant para? Income portion.
Only income portion.
So,
You
what was
shall
the...
straightway come to the page 48 then.
So, notional income fixed as rupees 5,000.
5,000 instead of 9,000. I have proved by adducing evidence.
Okay, employer was examined. Is he a businessman or an employee?
You will also kindly page 19.
Page
My
19.
deceased was a employee.
Deceased was an employee.
Yes,
So his employer was examined.
Yes, madam. Page
Yes.
19.
Jadi worker of Madina Jadi stores.
Yes, madam.
Yes. Page 19.
Yes, madam.
Yes.
Have you also got it, my lord?
Yes.
And so far the income certificate that has been marked as exhibit 11. You'll also kindly come to that certificate, page 35.
Yes. So this is the statement.
This is the witness. This is the statement.
Yes.
And so far, page 35, that is the certificate. That is marked as exhibit 11.
Date of accident when? 2016.
Date of accident was 2020, sorry, my lord. 2014, 8 September 2014.
Area Purbo Medinipur.
Yes, ma'am.
Yes, so this is your grounds that in spite of the employer having deposed, the learned court did not consider the income.
Consider what? You will also kindly come to page 48 once. He has taken part of the witness and part has not been taken care of. So kindly, may I read for your lordship's convenience?
Yes.
May I? The victim was aged about 33 years. Reading from page 48.
Third para.
Third paragraph.
Yes.
I'm so grateful. The victim was aged about 33 years, which is reflected from the Exhibit 9 voter identity card. According to the multiplier, 16 accordingly petitioner are 4 in number. That's 1/4 will be deducted. I am not reading this. I am reading the bold one. The petitioners to prove their income have examined the PW3 who has stated that he issued the certificate of income of the deceased person. But the said witness in his cross-section has stated that he has no document to show that the said deceased was working under him, and he also stated that he was issued the certificate without consider with any other document for payment of salary to the witness. In such case, I am of the view that the said certificate cannot be taken as granted for payment of the amount of salary of the deceased person. For the certificate bears the signature dated such and such after 2 years of the date of accident. Now you let's kindly come to the witness part of the employer. That is at page. Just give me a second, Mala. 19. Now pausing for a moment over here. Now you're also going to page 90 once. Yeah, page 90. I will also come. 19.
Page 19.
19.
Yes.
As per someone I have came before this court today, I am the proprietor of Madina Jari stores. I know Rajkumar Mishra who was working under me. I used to pay him salary rupees 9,000 per month. I have issued the certificate in this respect. This is the said certificate. That's this my signature and seal. This certificate is marked as Exhibit 11. Now, cross section. I have no document to show that I am the proprietor of the such and such Modina Jewelry stores. I have no document to show that the said person was working under me and I paid the salary to him. Now, I have issued the certificate without any document. It is not a fact that I am deposing falsely. Next, it is not a fact. I am not a proprietor of the said Modina Jewelry stores. It is not a fact. I never paid the salary to the said deceased person. These three has not been taken care of by the landed court bill.
The denial.
Only taken this part, not this part.
Yes, so this is with regard to the income aspect, and what else?
Nothing else.
Future
Only
prospect taken into consideration?
has already been taken. Only in respect of income now I am relying to judgment of this honorable court. I have handed over the copies of the judgment along with my notes of argument. Let's kindly come to the page 2017 SCC online Calcutta page 5033. The division main judgment.
Let us see.
Yes.
Okay, this one.
Yes, I have handed over.
Yes.
Just give me a second. Okay, একসঙ্গে বেঁধে দিয়ে দেবেন নাকি also got the judgment. Also kindly come to paragraph 19 statement. The judgment has central given. 2017 SCC online Calcutta 5033.
Yes.
Can come to paragraph 19 straight away. May I read one?
Yes.
Have you also got to paragraph 19? Turning the attention to the merits of the rival claims, we are unhesitantly of the view that the tribunal in the present case has made a mess. The coordinate bench in Pilasini Mondals has clearly laid down the law that the oral evidence is also the piece of evidence, and merely because no documentary evidence could be produced in support of the earning of the victim, such oral evidence cannot be rejected outright unless it is found unreliable from any other reason. The said decision was followed by the subsequent coordinate bench in Gopal Chandra Dey. We see no reason to take a different view. Evidence defined in section 3 of the Evidence Act 1872 is of two kinds, oral and documentary. All statements which the court permits or requires to be made before it by witness in relation to the matters of fact under inquiry are oral evidence. The term provided in the same section reads as follows. Proof. A fact is said to be proved when after considering the matters before it, the court either believes it to exist or consider its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Section 3 orders that evidence may be given in any suit or proceedings inter alia of existence of every fact in issue and other relevant facts. In terms of section 59, all facts except the content of the document or electric records may be proved by oral evidence. The requirement of section 60 is that oral evidence must, in all cases whatever, be direct. Should oral evidence on a fact in issue be not corroborated by documentary evidence, the tribunal may, in its wisdom, look for the corroboration. However, it is to be remembered that corroboration is not a rule of law but one of the caution as an assurance. It is not a rule to be rigidly followed. After all, it is not the quantum of evidence but the quality and credibility of the witness that ought to be lend assurance to the tribunal for its acceptance. At this stage, we may usefully refer to the decision of the Supreme Court reported in such and such. The normal rule which governs the civil proceeding is that a fact cannot be said to be established if it is proved by the preponderance of probabilities. This is for the reason that under the Evidence Act section 3, a fact is said to be proved when the court either believes it to exist or consider its existence so probably that the prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. The belief regarding existence of a fact may thus be founded on the balance of probabilities. The prudent man faced with conflict probabilities concerning a fact situation will act on the supposition that the fact exists. If on weighing the various probabilities he finds that the preponderance is in favor of the existence of the particular fact as a prudent man, so the court applies this test for finding whether the fact in issue can be said to be proved. The first step in this process is to fix the probabilities, the second to weigh them. So, two may often intermingle. The impossible weeded out of the first stage, the improbable at the second. Within the wide range of probabilities, this code often difficult choice to make, but it is the choice when the ultimately determines where the preponderance of probability lies. We are considering the appellant's claim viewed in the light of section 9(3) of the Evidence Act and tested on preponderance of probability. It is not improbable. The version of the appellant number 1, PW1, and the representative of the victim employer, PW3, were conformity with the requirements of the law of trustworthy and did not suffer from inconsistency, coordination, excavation, or embellishment. The burden of proof having been discharged by the appellant, the owner shifted on the insurer. The insurance did not adduce any evidence to disprove that the victim was a bus conductor working as a conductor. Victim could be drawn as 6,000 per month as monthly income, which quite reasonable. We are thus unable to agree the tribunal on this scope. Now you also kindly come to the witness of the PW1 with the wife. You also kindly come to the page. It starts from page 11. Kindly come to the straightway page 12. Paragraph clause 10.
Yes.
That my husband was a jewelry worker of Modina Jewelry Stores, proprietor Abdul Harisha at such and such, and used to earn rupees 9,000 per month. Everyone also got it, madam?
Yes.
And this will corroborate with the paragraph 19. Sorry, page 11, 19. The
No cross-examination. Any
so
cross-examination
far
with
the
regard
of
to?
the PW1. Yes, that has been also been there.
Yes,
Kindly come to
suggestion.
page
One
14.
suggestion.
Page 14.
Suggestion is given.
It's page 14. Not a here cross-examination. Have a lots got it.
Yes.
Now let's kindly read 1, 2, 3, 4, 5, 6, 7. 7 lines from the bottom. Not a fact. Have you also got it?
Yes, yes.
Not a fact. My husband was not engaged with the work of jewelry. Not a fact. My husband did not visit Kolkata to purchase the materials for work. Not a fact. My husband was more than age of 33 years. Not a fact that my husband had no earning rupees 9,000 per month as a jewelry worker. Jewelry worker. Not a fact. My husband had no permanent income. Not a fact. My husband did not die. This is the cross-examination. On cross-examination also. I would like to cite another judgment of the Honorable Supreme Court, my lord. It is reported in 2001 2 SCC page 166, paragraph 7. I will read only one paragraph from this judgment. Paragraph 17. Have you also got the judgment?
Yes, give that. Okay.
I have also handed over. Two judgments I have handed over. Yeah. I have judgment to bundle. May I get the speech one?
Yes.
Speech one, I have handed over the judgment along with my notes of argument. It isn't stitched. No, this is the notes of argument. Judgment copy of the
This is High Court.
Just I have read the one judgment from that one. Calcutta High Court's judgment.
No, High Court I have gone just
I
now.
have also annexed the judgment with that bundle.
With the written notes, you have annex that.
That bundle of judgment you also can hand over to me.
Bundle. Okay, okay. That then it will be here. Oh, this is the bundle of different judgments.
So another judgment you also can give it to me once. This is the another judgment.
Yes.
It is reported in my lord 2021 2 SCC page 166. Now you can kindly straightway come to the paragraph 17 once. have marked black mark. Paragraph 17.
This is, no, this is the first page of the Supreme Court judgment.
Yes, madam. Kindly come to paragraph 70.
70?
17.
Oh, 17.
Not got it.
Yes.
Paragraph 70. Haven't got it, madam. That there are two distinct categories of situation wherein the court usually determines notional income of the victim. The first category of cases relates to those where the victim was employed but the claimants are not able to prove her actual income before the court. In such a situation, the court guesses the income of the victim on the basis of the evidence on record, like quality of life being led by the victim and her family, the general in earning of the individual on that field, the qualification of the victim, and other considerations. But so far this case is concerned, there are 4 appellants, that is the wife of the victim, minor child, and father and their parents and his parents. Without the earning of 9,000 per month, it is not possible on his part to maintain his family. And I have produced the evidence, also the witness of the employer with the certificate, salary certificate, and proved that there is no contradictory evidence on the part of the insurance company to establish that so far my income as 9,000 is not at all true. Rather, in the cross-examination, both the PW1 and the employer denied the suggestion of the insurance company and proved beyond doubt that the deceased used to earn rupees 9,000. Deceased was a earning member and used to earn rupees 9,000 per month. And so far the cross appeal is concerned, they have also filed a cross appeal. Only to the extent of only one ground for the tribunal and odd in law while deducting 1/4 instead of 1/3 of the deceased towards personal and living expenses, since the father was one of the claimant. There is no evidence that the said father was dependent upon the income of the deceased, and so far this ground is concerned, but there is no evidence on the part of the insurance company.
How many dependents are there?
4.
4, okay. That means wife, how many children?
Minor son, minor child, and parents.
Okay.
So
if there are
4 are also the.
If there are 4 dependents, it should be 1/4.
1/4.
What is the age of the father?
Father age is, just to go through this. Just kindly give me a minute. Kindly give me a minute. I have annexed probably I have annexed the Aadhaar card of the father. Just give me a minute. When 2006. Thousand 22 years. Definitely, your lordship, father is presently now above 70. I don't know the exact age.
Father the claimant, 70 years of age.
His father also. আমি বললাম 22-এ হচ্ছে যদি ছেলের বয়স হচ্ছে তোমার আমি সেই হিসেব there is no such document that I have.
No, he has stated his age.
No, he has not stated anything.
Okay, the age of the person dead is 33 years.
33 years.
In that event,
when he's died.
Yes, yes.
There is no evidence on the part of the insurance company also. Let my learned friends first say. I will.
Yes.
Regarding income, regarding income, just kindly come to page 19, page 19 cross examination. Page 19.
Yes.
Page 19 cross examination. So-called employer who adduced evidence. It was said that I have no document to show that I am the proprietor of Modina stores. I have no document to show that the said person was working under me and I paid salary to him. Avocation, income has not been proved. But I have issued that certificate without consultation of any document. Without consultation of anything, this certificate of issued, and that certificate that is at page 35. Accident occurred in the year 2014, and it was issued in the year of 2016 after filing of claim application. After filing of claim application, this document, this witness is being procured. This document was manufactured. Kindly consider why the learned tribunal disbelieved the evidence of this at page 48.
Page 40?
Page 48.
Yes.
Bold portion.
Yes, petitioners to prove their income.
Yes. The finding that petitioners to prove their income have examined the PW2 who has stated that he used the certificate, issued the certificate of income of the deceased person. But the said witness in his cross-examination has stated that he has no document to show that the said deceased person was working under him, and also he stated that he has issued the certificate without consultation with any other document for payment of salary to the employee. In such circumstances, I am the view that the said certificate cannot be taken as granted for payment of that amount of salary to the deceased person. Further, the said certificate bears the signature dated 28/4/2016 after 2 years of the date of said person, and also after 3 months of the filing of this case. After date of 2 years after that, after filing of claim application, this document was issued. These documents were before filing of claim application. There's no malad. There's no evidence. After filing of claim application, it was procured to establish the income. No reason was assigned to issue the said certificate on the said date when the said employee was dead. In such circumstances, I am the view that the said certificate cannot be taken to calculate the income of the deceased person. Rather, a notional income, tribunal is absolutely just and proper while assessing monthly income notionally. Because there is no cogent evidence. The person came before the learned tribunal. He said that I have no document to show that I am the proprietor of that establishment. I have no document to say that the deceased was working under me. I have no document to show that I used to pay him salary of rupees 9,000. That is why learned tribunal disbelieved the evidence of the PW3. And what the PW1, that the widow said that I have that my husband used to earn rupees 9,000. The cross-examination portion, that insurance company denied that portion in cross-examination.
Yes, in cross-examination.
Yes, Your Worship, page 14. Page 14.
Yes.
Sixth line from bottom. Not sentence start, not a fact. From bottom, 7th line. not a fact, you got it, Malad? Not a
Yes.
fact, my husband was not engaged with work of Jodi. Not a fact that my husband did not visit Kolkata to purchase the materials for Jodi work. Not a fact my husband was more than aged about 33 years. Not a fact my husband had no earnings of rupees 9,000 per month as a Jodi worker. That suggestion was given. My humble servant evaluation, there is no error as committed by the learned tribunal while assessing monthly income of the deceased. Something must be there to establish the income of the deceased. Something must be there without consider anything. A piece of paper is issued as a called as certificate and say no, this was working under me and I used to pay him a salary of rupees 9,000 per month. But this cannot be a piece of cogent evidence, my lord.
Yes. Now with regard to deduction.
With regard to deduction, my lord. My lord. My lord, I am coming to Sala Verma's case. Sala Verma. First, Sala Verma, my lord, page 30, paragraph 30. 30 of Sala Verma. You got it, my paragraph 30.
Yes.
Though in some cases the deduction to be made towards personal and living expenses is calculated on the basis of units indicated in Tilak Chandra Supra, the general practice is to apply standardized deductions. Having considered several subsequent decisions of this court, we are of the view that where the deceased was married, the deduction towards personal and living expenses of the deceased should be 1/3, where the number of dependent family members is 2 to 3. 1/4 where the number of dependent family members is 4 to 6, and 1/5 where the number of dependent family members exceeds 6. Next, 31. Where the deceased was a bachelor and the claimants are the parents of parents, the deduction follows the defined principles. In regards to bachelors, normally 50% is deducted as personal and living expenses because it is assumed that the bachelor would tend to spend more on himself. Even otherwise, there is also the possibility of his getting married in a short time, in which the event that contribution to the parents and siblings is likely to be cut drastically. Here, my lord. Now, further subject to evidence to the contrary, the father is likely to have his own income and will not be considered as dependent, and the mother alone will be considered as dependent. In the absence of evidence, to the contrary, brothers and sisters also will not be considered as dependent because they will either be independent and earning or married to be dependent on the father. Here, Sala Verma says, until unless a specific evidence is adduced before the learned tribunal, father cannot be treated as dependent on the income of the deceased son. Subject to evidence to the contrary, the father is likely to have his own income and will not be considered as a dependent, and the mother will be considered alone as dependent. These are the findings of the and it was also upheld that state ratio also upheld in Pune Shetty's case also, that is page paragraph 40, you will find paragraph 40. Paragraph 40, you will find that in Reshma Company, 3 judges bench agreed with the multiplier determination eventually then annual balance. 41, 42 also 41, you will find that Sala Verma's paragraph is quoted. paragraph quoted and and the upheld the ratio as decided in Salavarma and Reshma Kumar regarding deductions, multiplier.
This is Pranay Shetty.
Pranay Shetty. Upheld the ratio as decided in Salavarma, Reshma Kumari towards deductions, towards multiplier. Only there is a departure on the issue of future prospect that in Pranay Shetty's case, self-employed persons also given the opportunity of.
So in this case, future prospect was considered.
Yes, considered. I do not have any issue regarding future prospect. Future prospect was considered. That Pranay Shetty also considered the ratio as decided in the Pranay Shetty. And also here kindly consider the paper book what evidence regarding dependency of father is being adduced before the learned tribunal. Page 11, the evidence of PW1, that is the widow. Paper book.
Page 11.
Yes,
Yes.
Page 11, my lord.
Yes.
Here, evidence of stateway, page 12. Page 12. Para 10.
Yes.
Para 10, that my husband was Jodi worker, Madina Jodi stores, proprietor Abdul Masisha, Tamil Purumazriba, and used to earn rupees 9,000 per month. 11. That my husband was Jodi worker. By his profession, he maintained his family from his income. Due to the death of my husband, we are facing with great economic crisis, and we shocked very much. That is the evidence of their dependency. Nowhere, here, the father was one of the claimant. Father was the petitioner here also. Father did not adduce any evidence to prove that he was unable to work and he was dependent on the income of his deceased son. There is no evidence. Only the wife said, widow says, we are dependent, we are. Nothing as general statement. Here also this portion is clarified in our High Court. An unreported judgment, that is decided by Justice Vivash Patnaik, 13. Shima Ghoshal. United India versus Shima Ghoshal. 13.1. With regard to deduction towards personal living expenses of the deceased victim, it is found that the learned tribunal deducted 1/3 towards the personal living expenses of the deceased. It is relevant to note that during the pending of the claim action, the mother of the deceased victim expired. Although during the pending of the claim proceedings, mother of the deceased died, but claim and legal liabilities crystallized at the time of accident itself, and changes posed thereto ought not to ordinarily affect pending proceedings, and I find substance in the submission of Mr. Mondal, learned advocate for the respondent's claimant in this regard, relying on the decision of Honorable Supreme Court passed in Kirti's case. In the aforesaid backdrop, the mother of the deceased victim is considered as dependent. However, in the factual background of the case, it is to be seen whether the father of the deceased victim may be considered as dependent or not. Mr. Mondal, learned advocate for the respondent's claimants, referring to the evidence of PW1, widow of the deceased, submitted that since there is evidence of dependency of father on the deceased victim, hence he should be considered as dependent of the deceased victim. Before proceeding to consider the aforesaid aspect, it is pertinent to note from page 8 and page 10 of the impinned judgment that the claimants admitted for deduction of 1/3 of the annual income of the deceased towards his personal living expenses, which was also considered by the insurance company and the learned tribunal. Upon consideration, deduction 1/3 of the annual income of the deceased towards his personal living expenses. Be that as it may, this is the important. Be that as it may, at this stage, it would be profitable to refer to the observation of the Honorable Supreme Court made in Salavarma and other reported in 2009 such and such, that subject to evidence to the contrary, the father is likely to have his own income and will not be considered as a dependent, and the mother alone will be considered as a dependent. Bearing in mind the opposite observation of the Honorable Court, it is found that the only evidence is of PW1, widow of the deceased, that they were all dependent on the income of her husband. The father of the deceased did not come before the court to depose in support of his dependency by making assertion of his incapability to maintain himself. Save and except a general statement of PW1, widow of the deceased, there is no other cogent evidence in support of the dependency of the father of the deceased victim. Thus, since the deceased at the time of the accident was married and there were three dependents, including the mother of the deceased, the deduction towards personal living expenses of the deceased should be 1/3. Until and unless, Salavarma said, until and also upheld that ratio as this is in Paneshetti, and this is was clarified. This is our High Court, that until and unless there is a specific evidence adduced by the father before the learned tribunal, dependency cannot be said to be granted. Father cannot be.
Sarala Verma, para 32 you have relied.
32 or 31? 30.
31, 32.
32.
32.
32.
There are 31. I have written in my notes of argument.
31. 31.
Yes, so that is with regard to the deduction.
Deduction. Yeah, Lanesh Tribunal
Deducted 1/4.
1/4, while my humble say it would be 1/3.
Yes.
But so far the paragraph 31 is concerned. You'll also kindly come to the judgment reported by the Sola Verma's judgment. Have you also got it, Pana? That petitioner, your lordship has to consider this was a married person. Now, so far the married person is concerned, that is applies paragraph 30. You will kindly read once.
Yes.
Though in some cases deduction to be made towards personal and living expenses is calculated on the basis of the units indicated in the Tilak Chandra, the general practice is to apply standardized deduction having considered several subsequent decisions of the Supreme Court where the deceased was a married. Have you also got it, Malak? The deduction towards personal and living expenses of the deceased should be 1/3, where the number of the dependent of the family 2 to 3, the 1/4, where the number of dependents of family means 4 to 6, 1/5. There is no such evidence, there is no such statement, or there is no such, I should say, there is no such condition that the dependency is to be proved. So far, married person is concerned. So far, now my learned senior friend has relied paragraph 31 that is related to the bachelor. It starts with the word where the deceased was a bachelor. So far, the married, that is paragraph 30. Paragraph 31 has no manner of application so far married person is concerned. Can you read this one, Malad? Where the deceased person was a bachelor. Have you also got it, Malad?
Yes.
The claimants are the parents. The deduction towards different principle in regard to the bachelor, normally 50% related personal and living expense, because it is assumed that the bachelor would tend to spend more on himself. Even otherwise, there is a possibility of his getting married in the short time. In such event, contribution to the parents and sibling is likely to be cut drastically. Further, subject to the evidence to the contrary, the father is likely, so far this part is concerned, according to my understanding, this will apply to the bachelor, not for the married. No, can't be.
In case of bachelor,
Sir,
50% stipulated.
Sir, I have not disturbed you. Sir, I have not disturbed you. There is no reply to the reply. There cannot be reply to the reply.
Yes,
No, there cannot be. There cannot be. So far my understanding. Further, subject to the evidence to the contrary, if father is likely to have his own income, this part it relates to the bachelor person, not to the married person, according to my understanding. Had there been any condition, there would have been recorded in paragraph 30, not in paragraph 31. I am reading 1 second for your lordship convenience, paragraph 31. So I am reading 1 second from paragraph 30. Though in some cases the deduction to be made towards personal and living expenses is calculated on the basis of the units indicated in the Tilak Chandra, the general practice is to apply standardized deduction. Having a considered several subsequent decision of this court, we are of the view that where the deceased was a married, I am pressing the issue married. So far this case is concerned, the deceased was a married. The deduction towards personal living expenses of the deceased should be 1/3, where the number of dependent of the family members is 2 to 3. 1/4, where number of dependent family members is 4 to 6. And 1/5, where the numbers of dependents of the family members exceed 6. There is a full stop. Now it starts another paragraph, paragraph 31, where the deceased was a bachelor and the claimants are the parents. The deduction towards different principle in regard to bachelors normally 50% is deducted as personal and living expenses, because it is assumed that the bachelor would tend to spend more on himself, full stop. Even otherwise, there is also possibility of his getting married in a short time. In such event, contribution of the parents and siblings is likely to be cut drastically. Further, subject to evidence to the contrary. Further, subject to the evidence to the contrary, father is likely to have his own income, will not be considered as a dependent, and mother is also mother alone will consider as a dependent in absence of any evidence to the contrary. Brother, brother and sister will not be considered as a dependent. So this part is related to the bachelor, not to the married, according to my understanding. Had there been any rider to that effect, so far the brothers and sisters, so far the married person is concerned, there would have been recorded in the judgment. There is no such recording.
That's all.
This is my subject.
Let me dictate the order. Thereafter, I'll tell you to give the calculations.
As well. So I have given the calculation so far.
So that is your way.
This is my way.
Your learned friend has his own way.
As
Thereafter, let me dictate. Yes, record an order.
One line submission. Only
Yes.
that portion.
Yes, he is replying to the cross objection. In cross objection, you are the opposition. To that, he is replying.
So far, that paragraph 31, matlab, regarding bachelor, 50% standardized, no issue. Here, why says further? That is the writer, further. That is applicable to what? That paragraph 31. Further, whether in case of death of a bachelor, father or mother was the dependent, was the claimant, in any case, 50% standardized formula, no issue, no 1/3, no 1/4. Here, further is considered in general, further subject to evidence to the contrary. Father is likely to have his own income and will not be considered as the dependent, and the mother alone will be considered as a dependent. Here, this further portion and brothers and sisters also taken into the consideration. No, brothers and sisters has a defined aspect. They have an own income. That brother, in case of a marriage, suppose, in case of a marriage, widow, minor son or daughter, anything, father, mother. Why not sisters and brothers will not be added as a party?
Because as per submission of my learned friend, here paragraph 30 says, in case of a married person, only paragraph 30 is applicable for a married person. Then my lord, brother sister shall also be included as a party to the claim application. They are also included in the family. No, then cannot be. In the succession, the Indian Succession Act,
Yes.
well, father is a class 2 years. Only the mother is.
No, actually, father may be entitled to compensation. Father, brother may be entitled to compensation. But so far the dependents are concerned,
Here,
that is to be treated in a different footing.
Here, Malak, in this deduction part, only the term used, not the claimants, not the legal representative, term used as dependents.
Yes.
That is the dependency you have to prove to get the benefit of this beneficial legislation. Further, until the evidence is adduced, yes, but in many cases the father is a
Handicapped person.
handicapped person having no income. Let him give evidence. Very well, I am handicapped person, unable to work, unable to earn. Of course, will be considered as dependent. Here, nothing. Only a general statement. That is what Justice Vivash Patana considered and clarified this position. Only general statement cannot do. Until and unless a specific evidence is being adduced by the father, because you are the party to the claim application. You have a right to adduce evidence to prove your dependency, but you did not to choose appear before the land tribunal. Only a general statement made by the widow. That is my humble submission. Therefore, 1/3 is to be considered instead of 1/4. Grateful to us.
Yes. Learned advocates for the parties are present are learned advocates. The appellants before this court were claimants in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 20/4/2021 passed by learned additional district judge, first track, second court, Tomluk, Purbo Medinipur, in MSC case number 12 of 2016. Stop. The case of the claimants before the learned trial court may be summed up thus. Para. On 8/9/2014, at about 6:30 p.m., the victim was proceeding by a bus bearing number WB19 capital G stroke 1260 through JL Nehru Road from north to south. Stop. When the driver of the said bus reached in front of premises number 31 JL Nehru Road near Bazaar, Kolkata, the victim attempted to get down from the bus. Stop. The driver of the said bus started suddenly without any caution. Stop. Next para. As a result, these victims sustained grievous injury all over the body, especially on head. Stop. After accident, the victim was taken to NRS Medical College and Hospital at Kolkata, but the victim died there on 11/9/2014 during the course of treatment. Stop. The accident was caused due to rash and negligent driving on the part of the driver of the offending bearing number WB19 capital G 1260 bus. Stop. Pursuant to filing of the case, notice was issued upon the opposite parties. Opposite party vehicle owner did not contest the case. Stop. However, opposite party insurance company contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. এটা হলো page 50, ঠিক আছে? 51. The appellant's claimants being aggrieved, the appellant claimants being aggrieved by the quantum of compensation awarded by the learned trial court has come up with the instant appeal. Stop. Similarly, the respondent, National Insurance Company Limited, being also aggrieved by the quantum of compensation awarded by the learned trial judge, has filed cross objection. Stop. Learned advocates, stop, ঠিক আছে? Heard learned advocate for the appellant and learned advocate for respondent claimant. Learned advocate for a respondent insurance company or appellant claimants. Peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that the learned trial judge erred in considering the income of the victim to be rupees 5,000 per month, although evidence was adduced by the claimant that the income of the victim was rupees 9,000 per month. Learned advocate further submits that the evidence of the claimant was corroborated by the evidence of the employer of the victim, who stated that the income of the victim was, that the salary of the victim was rupees 9,000 per month. Learned advocate also submits that the learned trial judge erred in ignoring the evidence of PW3, who was the employer of the victim. Learned advocate relies upon the following judicial decision. Number 1, Kirti and another versus Oriental Insurance Company Limited, reported in 2021 to SCC 166. Second, Tapa Ghosh versus Cholamandalam MS General Insurance Company Limited, reported in 2017 SCC Online, Calcutta 5033. Learned advocate representing National Insurance Company Limited submits that the claimants failed to prove the income of the deceased, and the learned trial judge rightly considered the notional income of rupees 5,000. Learned advocate further submits that the evidence of PW3 and the certificate issued by him is after a long period from the date of accident. Thus, the certificate cannot be relied upon, and the learned trial judge has assigned reasons as to why the evidence of PW3 cannot be relied. Learned advocate also submits that the learned trial judge erred in considering the personal deduction as 1/4 instead of 1/3, as the father of a victim cannot be considered to be a dependent. Learned advocate relies upon the decision of the Honorable Supreme Court in the case of National Insurance Company Limited versus Pronoy Shetty and others, reported in 2017 within bracket 4, TAC 673 SC, Shorola Bharma versus Delhi Transport Corporation, reported in 2009, 3 WBLR SC 700. Acha, next holo United India Insurance Company Limited versus Shima Ghoshal and others, FMA 4 of 2022 with Court 36 of 2021, Calcutta High Court within bracket. With regard to the issue of income of the victim, it appears that the claimant has stated in the claim petition that the income was rupees 9,000 per month and the victim was a Jari worker of Madina Jari stores. In the evidence adduced by the said claimant Krishna Mishra, being PW1, the claimant stated that her husband was a Jari worker of Madina Jari stores, proprietor Abdul Harisa at Demira Hut, and he used to earn rupees 9,000 per month. In the cross-examination, PW1 stated that her husband went to Kolkata to purchase materials of Jori work. Stop. She further stated that her husband was working under a person to perform Jori work and he used to go to Kolkata occasionally. Thus, from the cross-examination of PW1, it can be understood that now it will be clear that the victim was engaged as a Jari worker and the place was Madina Jari stores, whose proprietor is Abdul Hariza. The occupation of the victim is proved in the evidence of PW1. Stop. Although from the evidence of PW1, the income may not be proved, but upon considering the evidence of PW3, it appears that PW3 has stated that the victim Raj Kumar Mishra was working under him and he used to pay him salary of rupees 9,000 per month. PW3 has not only adduced oral evidence but also issued a certificate in that regard. As it is pointed out by the learned advocate that the employer, being PW3, has issued the certificate without consulting with any document, this court is of the view that when an undertaking is not a large and several workers do not work, it is not always necessary for the employer or the management of the undertaking to consult any documents to ascertain the income of an employee. From the evidence of PW3, it is clear that he had the knowledge that he used to pay the victim rupees 9,000 per month. Thus, the contention that the said witness did not consult any document to state the monthly income of the victim cannot be sustained. Further, considering the nature of work of the victim, the number of members of the family, and the age, this court is of the view that it is not unusual for the said victim to earn rupees 9,000 per month. Stop. Yes, now please give your calculation with regard to 9,000 and personal deduction of 1/3.
Let's direct to 1/3.
Yes. Both of you?
Calculate.
9,000 and that 1/3. আপনি কি কালকে জেনেছেন নাকি? বসুন বসুন হোক তারপর।
এই রুদ্রাসটা এই ফাইলটা রাখো তো।
জমা করুন এখন এই টাকাটা।
কোনটা জমা দিন?
এটা হয়নি জমা লোয়ার কোর্টে
করে দিই। জমা নিয়ে মানে কি বলছিস?
না গো, it has not considered that this will apply to the this will not apply to the married person.
Yes, I shall give my reasons.
Hmm? 1/3.
Yes. Thus, if the monthly income of the victim is rupees 9,000, the annual income comes to rupees 1,08,000. %, future prospect being added, the annual income comes to rupees 1,51,200. Although the learned advocate appearing for the claimant's appellant submits that in the decision of Sharola Verma versus Delhi Transport Corporation, paragraph 31 SUPRA, it is provided that where the deceased was a bachelor and the claimants are the parents, the deduction follows a different principle. In the said paragraph, it is also observed that the father is likely to have his own income and will not be considered as a dependent. Thus, the learned advocate submits that the father will not be considered as a dependent only if the victim was a bachelor. Stop. However, this court is unable to accept the ground submitted by the learned advocate. In paragraph 30 of the said decision, the Honorable Supreme Court has observed that though in some cases the deduction to be made towards personal and living expenses is calculated on the basis of units indicated in Tilak Chandra within bracket SUPRA, the general practice is to apply standardized deductions. Stop. Having considered several subsequent decisions of this court, we are of the view that where the deceased was married, the deduction towards personal and living expenses of the deceased should be 1/3, where the number of dependent family members is 2 to 3, 1/4, where the number of dependent family members is 4 to 6, and 1/5, where the number of dependent family members exceeds 6. Stop. Thus, in the paragraph 30 of the said decision, the Honorable Court observed with regard to the principles to be followed depending upon the total number of dependents. However, in the said paragraph, it is not observed as to who are the dependents. But in the paragraph 31, the Honorable Supreme Court clarified that in the usual courts, father is not the dependent. Stop. Thus, upon reading paragraph 30 and 31 together, it is clear that father is the dependent only in special circumstances. In the instant case, the claimants could not show any special situation as to why the father will be treated to be the dependent. Thus, 1/3 should be deducted on ground of personal deduction. Thus, annual dependency comes to rupees 1,08,000. The multiplier of 16 applied. The total compensation comes to rupees 16,12,800. Further, the claimants are entitled to compensation of rupees 70,000 on account of general damages. Thus, total compensation comes by arithmetical calculation to rupees 16,82,800. Stop. As 16,82,800. Stop. However, this court is of the view that rupees 16,50,000 is just and reasonable. Hence, this appeal, FMAT MB 493 of 2022 stands disposed. The judgment and award. FMAT আছে না FMA? FMA 450 FMAT MB কি এটা? এখানে কি লিখেছি? Okay. 493 of 2022, read with COT 59 of 2026, stands disposed. The judgment and award dated 24/4/20 passed by learned judge, first track, second court, Tomluk, Purbo Medinipur in MSC case number 12 of 2016, stands modified to the extent that the appellant's claimants is entitled to compensation of rupees 16,50,000 from the Respondent National Insurance Company Limited. Stop. The Respondent National Insurance Company Limited shall deposit rupees 16,50,000 along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, the balance deposit be made. The appellant's claimants will be entitled to withdraw the compensation upon compliance of necessary formalities. Stop. The deficit court fees be paid on the enhanced compensation if not paid. Enhanced compensation, definitely it is not paid. You also can record that if not. Deficit court fees on the enhanced compensation, if not paid, shall be paid within 4 weeks. The trial court records be sent by special messenger cost to be put in by the appellant's claimants within 1 week. So for? Yes. A special messenger cost for? Trial court records will be sent. That has not yet been arrived. Oh, trial court record aseni. Oh, the load kete din. But deficit court fees be paid. If not paid, I will definitely pay. Grateful. I am grateful.
Lord, before I start, Lord, I thank Almighty and Lord, congratulate your Lordship.
Okay, thank you very much.
We also bask in the glory of my Lord's, Lord, today's information, Lord. We think, Lord, that we as, Lord, in this determination, we have, Lord, to the best of our ability, Lord, we have helped a lot, your Lordship, to your Lordship, Lord, in this journey. Maximum number of disposals, not what we had.
Anyway, but you see, it is not a one-way traffic.
Yes,
it is the entire teamwork. If I have succeeded, it is due to the all efforts of the learned council staffs and everybody.
Yes, Lord. That is why I'm going to say we also bask in that glory, Lord.
Definitely, from all cooperation. And I just one more request that where the matters can be settled, you go before the settlement, because Honorable Supreme Court is also encouraging settlement.
Yes, we are trying. Lord. Congratulations again.
Okay, thank you. Yes.
Lord, this is a death case. Lord, this can be disposed of. Lord.
My Lord, congratulations.
Okay, thank you, thank you.
Lord,
So,
it will take me, Lord, 10 minutes of my Lord's time, Lord.
So it is quantum only.
It's quantum only, but my Lord, we need my Lord's blessings, my Lord, only 5 minutes, my Lord. My Lord, that's what we were discussing, Lord, if it can be disposed of, my Lord.
Okay, okay. So, what are the ground of challenge?
My Lord, it's on quantum, my Lord.
Yes.
My Lord, I'll just take 2 minutes.
Yes.
One 42-year-old man, he was a businessman. That's what, my Lord, the claimants claim. Lord, he died in an accident. Lord, accident is not disputed. Learned tribunal judge, my Lord, on the basis of rupees 10,000 monthly income, made the assessment. I mainly dispute, my Lord, this 10,000 rupees monthly assessment, my Lord, because there was no evidence. The only piece of evidence, my Lord, was the Gram Panchayat, my Lord, issued one certificate that this man was earning 15,000 per month. Learned tribunal judge disbelieved that it is an accident of 2012. Learned tribunal judge disbelieved that, but anyhow, my Lord, it assessed on the basis of 10,000 rupees. I came before this honorable court, my Lord, that if nothing is there, no document, my Lord, then it should be 5,000, 6,000, whatever my Lord pleases. On that basis, my Lord, I have come up before your Lordship. My learned friend, my Lord, has filed one cross objection. In cross objection, my lord, he stated that since Gram Panchayat granted 15,000 that certificate, so let it be increased to 15,000.
What is the occupation, nature of
My
occupation?
lord, he was a businessman. My lord, he was having a grinding machine for grinding masalas. My lord, we have worked it out. My lord, that calculation, my lord, we will show it to your lordship. My lord, we will not put my lord into much trouble. So, my lord, he has come up with a lordship in his cross. My lord, that was, my lord, as far as my part of my lord appeal was concerned, I said monthly income be reduced. And my lord, as far as the my lord, the general damages were concerned, more than 6 lakhs were awarded. 6 lakhs general damages under different heads, my lord. So it should be brought down to, my lord, 70,000, or if, my lord, the mother is to be taken as a claimant, then 1,14,000. That is the maximum. Mother is there, and my lord,
Oh,
the
filial consortium.
filial consortium. My lord is granting in a few of the matters, my lord. So that also, my lord, I have taken note of, but it would not be 6 lakh. It would be, my lord, maximum 1,14,000. I have calculated that. So that was, my lord, my part of, my lord, discontent with regard to the award passed by the tribunal. My learned friend, my lord, had come up, my lord, on the ground that compensation should be assessed on the basis of monthly income of 15,000 and future prospect was not granted.
But the Panchayat certificate was not exhibited.
But it was exhibited, my lord, the very last page of this paper.
Oh, Panchayat authority came.
No.
So how it is exhibited? Oh, anyway, without objection.
Without, my lord, no, my lord, it was there, but my lord, the widow filed this, my lord, along with other documents. The authority did not came, my lord, and we have got so many judgments, my lord. How come Panchayat would be knowing, my lord, the individual's income, my lord? That is disputed. Be that as it may, my lord. My lord, we have, my lord, made this calculation. Your lordship will, my lord, I am just handing it over to your lordship, my lord, for my lord's consideration. I have taken, my lord, note of, my lord, this cross objection as well, wherein future prospect was not granted. So,
Yes,
my lord,
that has to be granted.
my lord, that has, I have taken note of that and I have added that, my lord. Monthly income, my lord, whatever learned tribunal had granted, my lord, we are not disturbing that.
How much was awarded by the tribunal?
My lord, tribunal had awarded, my lord, 21 lakhs 34,500. My lord, that was inclusive of more than 6 lakhs general damages. Here, general damages, my lord, it is brought down to 1,14,000 in this calculation, my lord, what we have worked out together. So that is how, my lord, this 18 lakh something, 64,000 is the gross of, is the total compensation with 6%. It would be coming to around 34, 35 lakhs or 34 lakhs, so roughly, my lord, with 13 years of interest, 6%. It is an accident
Anyway,
of 2013.
21 lakh is awarded by the tribunal.
My lord, 21 lakh 34,500.
21 lakh 34,500.
So, my lord, we have worked it out, my lord. This is the most appropriate calculation, my lord. When monthly income is not touched, future prospect granted. My lord, multiplier is, my lord, is whatever it was, my lord, is 14. And, my lord, the general damages have been, my lord, the correct is, my lord, the 1,32,000, wherein filial is also granted, my lord. Taking everything into consideration.
Medical expenses, okay.
What was granted by the tribunal, it was proven, my lord, we have given that. So, on that basis, my lord, your lordship can dispose of this appeal, my lord.
So your ground of challenge is with regard to the this general damages.
General damages, and I had also contested, my lord, monthly income, but my lord is not disturbing that, my lord. We will take it.
Monthly income 10,000
lordship
without any documents.
Without,
and
my lord,
their cross objection
certificate. His cross objection is, my lord, on the ground of, my lord, future prospect
as well as the
monthly income enhancement, my lord. So we are not disturbing monthly income part. This can be disposed of.
Yes, take down.
We are grateful to my lord.
Learned advocates for the parties are present. Hard learned advocates. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 22/8/2014 passed by learned additional district judge redesignated court Paschim Medinipur in MSC case number 124 of 2013. Stop. The case of the claimants before the learned trial court may be summed up thus. On 28/3/2012 at about 6:30 p.m., Sri Vishwadev Chatterjee and Sri Anupam Paricha were going from Belda towards Mokrampur Bazar, and thereafter Sri Vishwadev Chatterjee stopped the vehicle of TVS-X L Super before Mokrampur Bazar at 6:30 p.m. Stop. At that time, Anupam Paricha was standing at the side of road. Then one offending vehicle bearing number WB36/6035 came from Narayanganj side with tremendous high speed and was being driven in a rash and negligent manner, dashed Sri Anupam Paricha. Stop. As a result, Anupam Paricha sustained grievous injuries in the head and whole body, and immediately he was admitted into Mokrampur Health Center by Vishwadev Chatterjee and others. Stop. From the said hospital, he was referred to Midnapur Sodor Hospital by private ambulance, and thereafter he was referred to NRS stroke SSKM hospital. Stop. On the way, he became seriously ill. Stop. As a result, he was admitted to Maurigram West Bank Hospital, and thereafter he was treated Neuroscience Institute, Mollik Bazar, Kolkata. Stop. From Neuroscience Institute, Mollik Bazar, Kolkata, the victim was admitted in SSKM hospital and his prolonged treatment continued till 18/7/2012. Stop. During treatment, huge amount was spent for medicine, X-ray, and blood, and also to take attendance for the said period. Stop. As a result of the accident, Anupam Paricha died on 18/7/2012. Stop. Next para. The accident took place due to rash and negligent driving on the part of the driver of Maruti van at a very high speed in violation of the traffic rules. Stop. Pursuant to filing of the case, notice was issued upon the opposite parties. Opposite party, vehicle owner, did not contest the case. Stop. However, opposite party National Insurance Company Limited contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Stop. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. এটা কোট করে দেবেন, এই বলে দিচ্ছি পেজ 44, ঠিক আছে, 44-45
44-45.
The appellant, National Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. The respondents' claimants, being also aggrieved by the quantum of compensation awarded, has filed cross objection. Stop. Heard learned advocate.
Respondent number 1 and 2.
Oh, there is only one respondent.
No, there are three claimants, my lord. My lord, three claimants are, my lord, the widow, daughter, and mother of the deceased. My lord, learned tribunal judge had granted, my lord, this compensation in equal share to all three. But, my lord, in Honorable High Court, the mother, the widow and the daughter of the deceased, they have come up, my lord. And mother, my lord, of the deceased has been made as a performer in High Court.
And vehicle owner?
Lord, vehicle owner is there. Vehicle owner is there.
Respondent number?
Lord, vehicle owner is not respondent number. The
okay, so you are representing respondent number 1 and 2.
Mother and the widow and daughter.
Anyway, respondent number 1 and 2. Respondent number 4 is probably the performer respondent.
My lord, page number 46, my lord, is the memorandum of appeal.
Yes, 46.
Lordship, my lord.
Yes. So 3 is the vehicle owner.
3 is the vehicle owner.
Yes.
And where is thereafter?
My lord, the 2A, your lordship will kindly say, my lord.
Oh, 1, 2 and 2A.
Yes. My lord,
he was subsequently
2A is the mother of the deceased.
So your learned friend is representing 1 and 2.
Widow and daughter.
Okay. Heard learned advocate for the Appellant National Insurance Company Limited and learned advocate for respondent number 1 and 2 claimants. Stop. Peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that the learned trial judge erred in considering the monthly income of rupees 10,000 without any documentary evidence. Learned advocate further submits that the compensation awarded on account of general damages to the extent of, what is the quantum?
What passed by the
No,
tribunal?
no, the general damages.
General damages, the quantum is 6,02,500.
6,02,500 is excessive. Stop. Learned advocate also submits that the compensation awarded by the learned trial court should be reduced. Stop. Learned advocate appearing for the respondent number 1 and 2 disputes the submission of the learned advocate for the appellant and submits that although the certificate which was issued by the Panchayat authority was filed in court, learned trial judge erred in considering the monthly income of the victim as rupees 10,000. Stop. Learned advocate further submits that the learned trial judge erred in not awarding any future prospect. Stop. With regard to the submission of learned advocate for the appellant with regard to monthly income of rupees 10,000, this court is of the view that the learned trial judge has.
Reasoning is given at page 42, last
Yes.
paragraph.
Yes,
And
yes,
page
yes,
40.
yes.
Great, good.
Learned trial judge has assigned reasons for considering the income of the victim as rupees 10,000. Moreover, nobody has come on behalf of the Panchayat authority to adduce evidence. Panchayat authority to adduce evidence. Thus, the learned trial judge did not commit any error in considering the monthly income of the victim as rupees 10,000. Stop. In the event the monthly income is considered as 10,000, the annual income comes to rupees 1,20,000. Future prospect of 25% being added, which is 30,000, the total monthly income comes to rupees 1,50,000. Stop. 1/3 should be deducted on account of personal expenses, and the annual dependency loss comes to rupees 1 lakh. The multiplier of 14 applied, the total dependency loss comes to rupees 14 lakh. The medical expenses incurred being added comes to rupees 1 lakh, so comes to rupees 3,32,000. The general damages in the instant case may be, should be rupees 1,32,000. Thus, total compensation comes to rupees 18,64,000 by arithmetical calculation. Stop. However, this court is of the view that compensation of rupees 18,50,000 is just and reasonable. Hence, this appeal FMA 3381 of 2016, read with Court 105 of 2018, stands disposed. The judgment and award dated 22/8/2014, passed by learned additional district judge, redesignated court, Paschim Medinipur, in MSC case number 124 of 2013, stands modified to the extent that the respondents number 1, 2, and 2A shall 1, 2 and 2A.
One thing, my lord, 6% interest may be calculated.
Yes, 1, 2 and 2A is entitled to rupees 18,50,000 from the Appellant National Insurance Company Limited.
My
Stop.
lord, one thing may I submit? My lord?
Yes.
My lord, the father-in-law is alive, my lord. Just my lord, respondent 1 and 2.
1, 2 and 2A.
2 is the widow, with the
Milord, what he says, Milord, that the maximum, Milord, the widow, the daughter and mother, all are getting, Milord, in Milord, equal share.
That is what is passed by the trial court.
What he is submitting, Milord, the father of the deceased is alive. He is getting his pension. He was in a government school, Milord. He is getting his pension. So he is praying before your lordship that if the ratio of mother, who is not here before your lordship, can be reduced a little, and the widow and daughter can be, Milord, given a little more compensation. This is what he
40%,
wants.
41, 20%, if your lordship.
It can be given.
It
This
can
is what
be.
his prayer is.
Okay. The claimants, respondent number 1, 2 and 2A are entitled to rupees. Okay, let it be instead of 18,50,000, let it be this 19 lakh then. It will be easier.
I'm not supporting you. You're not sure.
Okay, 18,50,000. Okay. I have reduced it. Usually I increase. I have reduced it. The claimants, respondent number 1, 2 and 2A are entitled to compensation of rupees 18,50,000 from the Appellant National Insurance Company Limited. Stop. The Appellant National Insurance Company Limited shall deposit rupees 18,50,000 along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. Stop. It is further clarified that the respondent number 1 will be entitled to compensation.
1 and 2, my lord.
Yes.
Daughter and widow. %, 20%.
She will, Milord, indicate, Milord, the compensation should be disbursed in the following ratio, if it suits your lordship, Milord.
Yes. Actually, it should be 6 lakh. If 1/3, 1/3, 1/3.
Milord, this amount would not make any difference. It is the percentage, Milord.
Yes, amount is there. Suppose it is 18 lakh. Okay.
Yes, Milord.
666.
Yes.
That is 1/3, 1/3, 1/3.
Your lordship will only indicate 1/3, 1/3, 1/3. Or, Milord, 40%, 40%, 20%.
Yes, my lord.
Okay.
That will be better.
If it suits your lordship, Milord, of course.
Appellant.
Appellant
number, the respondent number 1A.
1 and 2.
Respondent number 1A shall be entitled.
Milord, 1 and 2.
1 and 2.
Just respondent number 1 shall be entitled to compensation of rupees. Respondent number 2 is not minor.
Milord, 2 is
No, I have now major.
He has attained majority.
Compensation of rupees 8 lakh. The respondent number 1. Respondent number 1 is entitled to compensation of rupees 8 lakh. Respondent number 2 is entitled to compensation of rupees 7 lakh.
8 lakhs, my lord.
7 lakh. And the respondent number 2A is entitled to compensation of 3,50,000.
3.5 lakhs, yes.
3,50,000.
Deeply applied.
Milord, with interest, with due interest.
Yes. The claimants will be entitled to withdraw their share of compensation along with interest upon compliance of necessary formalities.
This line is perhaps not the Milord. Insurance company has deposited the awarded sum before your lordship's court.
ওইখানে তাহলে ওইটা করতে হবে। The appellant insurance company shall deposit. আচ্ছা, একদম সকলের তলায় করে দিন। It is however clarified that in the event compensation awarded by the trial court is already deposited, no further deposit be made. Upon withdrawal of the compensation amount by the claimants, The balance, if any, with accrued interest shall be returned to the appellant insurance company.
Extremely grateful to my
My lord, one thing, my lord, kindly direct to the register to
That they will take care.
my lord, kindly
Your case is not isolated case. So many
because my
cases.
lord, people puja vacation they will get something.
Okay. If you have problem, you just
My lord,
mention. I
kindly
shall
one
see.
thing, my lord, within 8 weeks, my lord.
8 weeks, they 8 weeks actually, if they have, as because they have already deposited.
Deposit already
I've
deposited.
clarified that. Okay.
My lord, one line, my lord, if before puja vacation they will get something, my lord.
Okay, if you don't get to mention, I shall see
My
to the
lord,
matter.
one line, my lord, only one line.
See, if I do in your case, then in all cases I have to do that.
No, my lord.
That will cause some problem.
My lord, I am not regularly come before your lots of my claim case. I am only, my lord, one first time I have mentioned before only one within 8 weeks or 6
Your
weeks.
Lordship will make it expeditiously.
Okay, the claim amounts shall be released upon compliance of formalities expeditiously.
As possible as my lord.
Now,
I'm deeply obliged. I'm deeply obliged.
extremely grateful to you.
Deeply obliged.
একটা ম্যাটার আছে,
Thank you so much.
একটা তো কেউ নেই এখন।
Thank you so much.
Thank you.
হ্যাঁ,
पाँच पाँच
Both are your matters?
No.
Only one?
I'll say very, in the meantime, he's searching, my lord. I'll say what is the background, my lord. There was a decree, my lord, before DRT in 2001, my lord. And 22 lakhs decree, my lord, as per your lordship's, my lord, predecessor's order, my lord, I have already paid 21 lakhs. Only 1 lakhs and odd was given and it was stayed. In the meantime, my lord, the matter got dismissed for default and now they
This
are.
is what can 12451.
My lord, those are perhaps dismissed.
Old.
It's a change brief, but.
Okay. So this is the old case, old number. Can 12451 means old number?
Old numbers are different, my lord.
Old number.
Huh.
Previous number is
Can, yes.
Can 5.
Yes, ma'am.
Can 5 of 2019. When it was dismissed?
Well, it was dismissed on, the impugned order, it was dismissed on 26th November 2019, just before the COVID. And after that, the COVID approached.
26th November 2019.
Yes. And within a week, my lord, we filed this restoration application.
Yes, record an order. Learned advocate for the petitioner is present. None appears for the respondents. It is only presiding officer or the bank authorities are also?
Bank is also there.
Okay.
Presiding officers, they will not appear.
No, the bank authorities are party.
Yes, my lord.
Okay, you have served the bank authorities.
I have placed the
Okay. None appears for the respondents in spite of service of notice. The affidavit of service file be kept with the record. This is an application for restoration filed by the petitioner with a prayer for recalling the order dated 26/11/2019, passed in CO number 3021 of 2001. Upon perusing the petition and upon hearing the learned advocate, this court finds that the petitioners have furnished grounds for not being present on the date fixed when the matter was dismissed for default. Thus, the order dated 26/11/2019, passed in CO number 3021 of 2011, stands recalled, and CO 3021 of 2001 stands restored to its file and number. Liberty to mention after 5 weeks.
My lord, whether it will be required or not, I do not know, my lord. In that day, my lord, interim order, if any stands vacated, that has to be specifically recalled or it automatically goes, my lord.
But by virtue of this restoration, the interim order passed earlier also stands restored.
Much obliged.
Can item 2?
Next item number 2.
I'm not.
আচ্ছা এই দুপুরে মোটামুটি for what purpose you are mentioning?
My client is appellant and he's died.
No. For what purpose? Why are you mentioning the matter? You want to file any application?
No. Substitute petition.
Substitution petition you file and you give the case number, it will appear in the list.
No.
কোন মামলাতে আছে?
CO 1957/2019.
Which question is you go, you just ascertain.
Department no allow the application for generator of the my corporation death certificate. But I am file the hospital death certificate and
No,
rural
question is,
certificate.
anyway, you have a talk with the court officers.
The matter, my lord. This matter, my lord, is at serial number 45 of your lordship's list, my lord. This is for extension of the interim order, my lord.
Who is appearing for the other side?
My lord, the railway authorities, my lord, had appeared, my lord, in the interim
Yes,
order.
record an order. You have served notice of mentioning.
My lord, I've informed them, my lord. My lord, I don't have the copy, my lord. I'll again mention, my lord, at the time of rising, my lord, if your lordship permits.
Okay, so,
My lord, I'd informed them.
serve notice and mention tomorrow morning.
My lord, can I mention it, my lord, before rising, my lord, before your lordship rises?
If you can bring him, well and good.
Very well, my lord. Good.
For the claim in this part.
Yes, hence this appeal FMA 457 of 2025 stands disposed. The judgment and award dated 11/4/2022 passed by learned trial judge is confirmed with regard to the principal compensation awarded. However, with regard to the rate of interest, the same is reduced to 6% per annum. The appellant insurance company is granted liberty to recover the compensation amount from the vehicle owner, the respondent number 2. However, as 3 years have passed and no award was passed against respondent number 2, the respondent number 2 is granted opportunity to pay the compensation amount to the insurance company by 12 equal monthly installments. The monthly installments shall be decided between the parties amicably upon notice to respondent number 2 and by holding discussion, failing which necessary direction may be obtained from trial court. Anyway, then the claimants will be entitled to withdraw compensation upon compliance of necessary formalities.
Deeply obliged, my lord. Grateful.
Yes. Hence, this appeal FMA 1152 of 2025 stands allowed. Judgment and order dated 11th April 2025 passed by Learned Railway Claims Tribunal, Kolkata Bench. In railway claim application number so-and-so is set aside. The appellants are entitled to compensation of rupees 8 lakh from respondent along with interest at the rate of 6% per annum from date of filing claim case till today. The respondent shall deposit rupees 8 lakh along with interest at the rate of 6% per annum before Registrar General High Court, Calcutta. Such deposit shall be made within 8 weeks from the date of communication of this order. The appellants will be entitled to withdraw the compensation upon compliance of necessary formalities.
My lord, I am for the respondent.
My lord, on the last date, when this appeal was taken up,
yes,
on behalf of the appellant insurer, my lord, I had made my argument.
So what is the ground of challenge? Yes, see, this is with regard to probably that insurance recovery, the insurance, the liability of the insurance company, probably.
Lordship, my lord, this was with regard to the bouncing of the premium check.
Yes,
Liability
of the insurance company.
Lordship, my lord, the premium check being dishonored, my lord, learned tribunal judge.
So your learned friend wanted to distinguish the judgments.
Yes,
on the last
yes, yes.
occasion.
My lord, just for the recapitulation, my lord, 2 minutes.
Yes.
My lord, at page number 13 of this paper book, 14, my lord, to be precise.
You filed your written notes.
No, my lord, on the last date, my lord, I had just concluded my argument. Written note, my lord, perhaps it was not required.
Anyway, question is, after your learned friend concludes, you can do so by
Lord, if your lordship feels so, my lord,
considering the nature of the case.
my lord, if your lordship feels so, my lord, I will definitely
So
file.
all points are considered.
My lord, if my lord feels so, my lord, I'll definitely file my written notes. My lord, I'll just recapitulating, my lord, the entire thing. My lord, this was the premium check, my lord, was dishonored. The notice was given to the insured. And my lord, after the notice, my lord, this accident took place.
Honorable Supreme Court, my lord, in all the three judgments, my lord, what I have cited before your lordship, has made it clear, my lord, that when the notice is given, my lord, and after that the accident takes place, insurance company is not liable. Rather, in the third judgment of Sunita, my lord, it is very clear that the claimants should take the compensation straightway from the owner of the vehicle. Insurance company was absolutely exonerated. That was, my lord, in that case, my lord, the notice was given prior to the date of accident. My lord, in this case also, your lordship will kindly take note, my lord, the instant, the one what we are arguing before your lordship. Page number 14, my lord, your lordship will kindly see.
Page running 14, yes.
Page running 14, my lord, the top second line. However, he is at liberty to realize the same, my lord, he means, my lord, the insurance company, afterwards from the OP number 1 in a separate proceeding. But in the ordering portion, my lord, this liberty to recover was not granted. But I was not on the recovery part. My lord, recovery in any event, my lord, I would get. I have no doubt about that. But I was saying, my lord, and I was arguing on the point of absolute exoneration. My lord, the three judgments, my lord, what I had cited before your lordship, 2007 Dedappa, 2000, Lord, thereafter 2012 Lakshmamma.
Yes, one is National Sunita Devi.
Last is the Sunita Devi, my lord, 2025.
Lakshmana.
Yes, my lord. My lord, 2007, my lord, is Dedappa. 2012 is Lakshmamma. And last one is Sunita. My lord, all these three judgments, my lord, had taken note of all earlier judgments.
First one is Justice SB, presided by Justice SB Sinha.
Lordship, Dedappa.
Yes.
Yes, presided over Justice SB Sinha, my lord. Perhaps my lord had taken note of, my lord, in paragraph 17, 18, 19, 20, 26, 27, and 28. In the last paragraph, my lord, if I can just indicate to your lordship. Prior to that, my lord, it was held that insurance company is not liable. But in paragraph 28, my lord, their lordships use article 142.
That is 88/2025.
88.
Sunita Devi.
No. Dedappa, what my lord referred
Very
to.
first one.
SB Sinha.
Yes.
Lordship, as his lordship then was, my lord. My lord, paragraph 17, 18. My lord, I'm not repeating the paragraph since I had showed it to your lordship. Perhaps my lord has taken a mark of that.
Anyway, you clarify it. You have argued. You clarified in your written notes.
Yeah, my lord, I'll just indicating, my lord, in the
And
last paragraph.
you can take these judgments back and enclose.
No, my lord, judgments I have. Judgments I have, my lord. I was just indicating in the last
17.
My lord, paragraph 28, the last paragraph.
28.
It started from paragraph 17. But
yes, this is the exercise of power under 142.
Yes, my lord, their lordship
said. Principles behind this order.
Yes, lordship said insurance company is not liable. Insurance company not to pay.
This is a special power invoked.
This is the special power. My lord, that is why their lordship said, okay, fine, you pay and recover. Otherwise, had 142 not been invoked, insurance company not liable.
You see, there are two things, you see.
Lordship.
That is, you see, violation of this thing, terms of policy.
My lord.
That means pay and recovery is one thing.
Extremely grateful to your lordship.
And the other is this non-existence of insurance.
I'm extremely grateful to your lordship.
Pay and recovery, that is a different principle.
My lord, this is
different issues.
This is exactly what I am, Lord, why I am here before your lordship. In this case, there is no policy. Had the policy been there,
yes, violation of condition.
Then condition, my lord,
yes, then pay and recover or whatever it is.
Lordship.
He may not recover also. Whatever it is.
That is why the lordship said insurance company not liable. But by invoking 142, they said that okay, fine. In this case, in this only case, my lord, you pay and then you recover.
Sometimes the case may be yes, insurance policy is there. All are not under the coverage.
My lord.
Also to some extent.
There are also policies there. Here the policy is not there. Lordship.
If policy is there, then the court can give some
my lord. I'm grateful to your lordship.
Anyway, let us see.
This was the Dedappa. My lord, the second one, my lord, was Lakshmamma. 2012. Justice Lodha.
Yes.
My lord, in this case, paragraph, my lord, 20 and 21, my lord, I had again, my lord, spoken, my lord, shown to your lordship. In this case also, my lord, the insurance policy was not there, but my lord, since their lordship held that the intimation was after the accident, that is why, my lord, your right to third party, my lord, would not extinguish, and then you recover. Liberty to recover was there. Notice was after the accident. That was the reason. Otherwise, my lord, again, insurance company not liable. And the last one, my lord, which was the clinching one, 2025, the very last judgment, Sunita, what my lord had pointed it out, my lord. The very last paragraph, my lord, I am not troubling your lordship with the other paragraphs. Last paragraph, my lord, 6 and 7.
Yes, 6.
6, my lord, that is the important part. In the totality of the operative facts, the court is of the view that the 50% amount which is already paid to the claimants need not be touched. Since it was claimant had already received, my lord, Therefore, it is provided that there shall be no recovery from the claimants in respect of the said 50%. What claimant had already received? The appellant insurer, however, shall be at liberty to recover the said 50% from the owner. Then, my lord, the last sentence, as far as the balance 50% is concerned, which remains, the claimant shall be entitled to recover the same from the owner. Insurance company, absolute exoneration.
How much was the quantum?
My lord, whatever the quantum, I'm on principle, my lord, I'm not on quantum.
No, in this case.
8,23,000.
8,23,000.
Lord, I'm on
Out of which
principle.
how much was paid? 50%.
50%, 4 lakh. Lord, 50% was also, my lord, not liable to be paid, but since they had already withdrawn that amount, that is why court said, okay, you do not take it back from them, take it from the owner, but for the balance 50%, you will not pay. The claimants will pay from take it straight from the owner. This instant case is 163, my lord, what we are arguing. The amount is 1,87,000. I'm not on amount, my lord. I'm not on the figure. On principle, your lordship will
The
find
amount is how much? 1 lakh?
1,87,000.
87,000.
It's 163, my lord, a case of 2005. So it was more than what it was.
1,87,000.
187,000. So, my lord, I am not an amount, but my lord, on principle, Supreme Court is time and again, my lord, initially, Rula or Inderjit Kaur was there, my lord, pay and recovery was there, but now regularly Supreme Court says insurance company not liable, not liable, not liable.
See, this is the one question. You see, when
Lordship.
policy is not in existence, how a company can be made liable?
I'm extremely grateful. This is what Supreme Court is holding, my lord. This is what Sunita is exactly.
Is this policy is there violation of some condition?
My lord, my lord, my lord. This is what my argument is. This is what I have placed before your lordship.
All the judgments as a
Lordship,
and
lordship.
see how far it is applicable.
Lordship. And these 3 judgments have considered all earlier judgments also. I'm obliged to your lordship.
Yes.
My lord, kindly see the judgment of 3 judges bench, including Chief Justice of Supreme Court. My London friend, 2 division, double bench judgment and 1 single bench judgment.
Inderjit Kaur.
Yes.
Yes, it was okay.
Yes. Where the insurance company is liable for third party risks, yes, despite the bar created by section 64, the insurance company issued a policy to cover, but without receiving the premium. Without receiving the premium. So, my lord, by reason of provision of 147(5) and 149(1), the insurance company became liable to indemnify the third party liability.
That is page? Which paragraph you are reading?
Paragraph 8.
Paragraph 8.
Yes, my lord.
Yes.
So, here the insurance company, in spite of without receiving the premium, insurance company is liable to third party risks. I am a third party. This is 3 judges bench of Supreme Court. Now, kindly, my lord, see another decision of Supreme Court. And then, here the Supreme Court, just first page, whether insurance company exempted from third party liability of check towards premium is dishonored and policy is cancelled after accruing of liability. Hell no. Payment of premium is not the concern of third party. Subsequent cancellation policy due to dishonour of check would not affect the rights of third party which had accrued on the date of the accident. This is the decision of this Supreme Court. Naam hobe India Bhacha Rula.
Thank you.
নিশ্চয়ই নাম হবে।
No, what is the para 9? Okay.
Yes, my lord. This is para 9, my lord. এই টুরিংটা বার কর 1307 বার কর 1307 দেখ 1307 পেয়ে গেছি
So, okay.
Then another thing, this is the Supreme Court decision. I'm holding the page. Now let's see para 18. Para 18 again. Para 18 of the judge. I have cited two decisions, my lord.
My lord, may I know the reference, my lord? Again, the same problem.
Yes.
Reference is not being.
Now, one is Indrajit Kaur, another is I have already told Rula.
These are mainly this TSC and ACJ.
My lord, I need the name, my lord. Given
Okay.
the reference, the name would suffice.
name you
Name
take
would
it.
suffice. এটা কোনটা দেখাচ্ছে?
এটা দেখাচ্ছি আমি, you have already given Lakshman.
Oh, Lakshmana.
বলো না, বলে দাও না। বারবার বলতে হয় কেন?
Yes, what is the relevant portion?
Relevant portion 18, para 18, my lord. Para 18. We, same point was reiterated there. Para 18, my lord.
Yes.
We find it hard to accept the submission of learned counsel for the insurer, that is insurance company, that the three judges bench of decision in Indrajit Kaur 1998-123 SC had been diluted by the subsequent decision. This point was raised here. The decision 2008-581. Dadappa and Sima Malhotra. Reference was, in this case, the insurance company raised the point that this decision has been diluted by the subsequent decision of these two decisions, which my learned friend referred. Then Supreme Court observed, in case of Sima Malhotra, the claim was by the legal heirs of the insured for the damage to the insured vehicle. In this particular fact situation, the court held that when this check for premium return dishonored, the insurer was not obligated to perform its part of the promise. In so far as the Dadappa is concerned, it was a case where the accident of the vehicle occurred after the insurance policy has already been cancelled by the insurance company. So now, in this regard, I have cited the constitution bench decision. Earlier decision will prevail.
Illegible copy.
Huh?
This is an illegible. Anyway, Mr. Singh has filed this decision.
My lord, this is the decision of the Honorable Supreme Court, 5 judges bench. This is constitution bench decision. কোথা সেটা? ওটা দিয়ে? ওটা না,
Yes. Land acquisition.
ওখানে প্রিন্সিপালটা আছে। The earlier decision will prevail. এটা কোথায়? এটা নাও, এটা নাও। এটা না, ওই ফাইলটা কি? এই my lord, kindly see page 1934. This is the decision of Union of India versus Pitpal Singh and others. THL, PL. The Supreme Court decision, binding value. Decision given by the division bench, binding on decision bench of same or smaller number of judges. A pronouncement of law division bench of Supreme. My lord, kindly see para 29. It has explained here. Earlier decision will prevail on the same point.
Yes.
My lord, para 28, para 28, my lord.
28?
28, my lord, yes.
Yes.
Not 29, 28, my lord. Here also same point was involved. What then should be the position in regard to the effect of law pronounced by a division bench in relation to a case raising in the same point subsequently before a division with smaller number of judges. Same point was involved here. Now the coming down, it is in order before 7-8 line from bottom. It is in order to guard against the possibility of inconsistent decisions on point of law by different division benches, that the rule has been evolved in order to promote consistency and certainty in the development of law and its contemporary status, that the statement of law by a division bench is considered binding on a division bench of the same or lesser number of judges. This principle has been followed in India by several generations of judges. Then another AIN 1975, Supreme Court 2009, where also same thing was several decisions was written in this judgment and clarify the matter. We are of the opinion that the pronouncement of law by a division bench of para 29, binding on a division bench of same as number of judges. So my decision was earlier decision. A 3 judges bench decision, number 1. Number 2, another decision also I am citing, my lord, here also expressed it. Khadija versus Rusdi. My lord, kindly see it. I have underlined. What are they? 80. ঠিক আছে
এক সেকেন্ড দেখা যাবে বললেন না ব্রিফ ফাল এর আগেরটা
বলে দিচ্ছি, পরে বলে দিচ্ছি, দেখে বলতে হবে
না হঠাৎ এক্ষুনি দেখালে
My lord, kindly see page 430. 403. Second page, my lord. 402, 403. Second page, my lord.
Yes.
My lord, kindly see Constitution of India, Article 141. Interpretation of state. Decision rendered by earlier bench of apex court, doubted by subsequent coordinate bench, and matter referred to a large bench. Reference will not amount to stay of earlier verdict, nor does it mean that the earlier verdict will be inoperative. Earlier verdict by the apex court is law of the land by virtue of the Article 141 until it is valid. So this is another reason. My lord, one thing, my lord, kindly go through the lower court records where it was not served, so it is within the knowledge of the, though there is evidence, but non-knowledge of the insured.
What is the findings of the learned judge? Let us see that.
No, first finding, it was not served upon the OP1. That is the more that is the whole criteria in this
Anyway,
case.
OP1
If it was not knowledge.
OP1 is not before us. No, the findings of the judge is.
If it is not knowledge of the OP1, then.
No, which one? The notice.
Yes.
The notice. What is the findings of the judge?
Judge,
Because that findings is not
see.
challenged before this court. Okay. So the court has come to the findings that,
yes, my lord,
that it was duly communicated and there is no challenge with regard to the said findings.
Lordship will kindly to page number 13, Millard. Running page 13 of this paper book.
1-3.
Lordship.
I know how to read. Please wait.
No,
Your turn, I do not say anything. Your turn, I do not say anything. Please wait.
Okay, page 1-3.
Lordship. Not the first,
You
second
have
paragraph.
done enough time you have taken, just you take seat.
Okay.
Patience.
Where is the findings that the notice was served or not served, whatever it is?
It is very much required in this case.
Where is that notice? There is no challenge with regard to the findings. So whatever the learned judge has observed, it is that has reached its finality. So unless there is a findings, okay, that the notice was not duly served or the vehicle owner had no knowledge, okay, then that's a different issue. But where is
The law is that without knowledge of the owner insured, you cannot take any decision.
No, question is, you see, but what is has the learned court come to the conclusion that it was not within the knowledge of the
Come to
owner?
page 23, my lord, first of all, and then page number 13.
Because you see, the court,
Yes,
the
yes.
court in appeal will not go into those findings.
My lord,
Because
yes, this is exactly, my lord's question, query is not being answered. Page 23, my lord.
Had another one day.
Don't cry, please.
No. This is not the way to.
No, just
There is enough time.
you see,
And
both
you have
of you,
taken enough time. When I
both
am
of-
saying, then you raise the point.
both of you just show me where is that findings.
Exactly, my lord. A finding is at page 13, which is relevant, my lord, subsequent to page number 23, the deposition, my lord, of the DW.
Page
One.
13.
Page 13.
Yes, page 13.
Lord, second paragraph, starting with the word however. Is my lord there, my lord?
Yes, peruse the materials on record.
Not considering the matter, I have carefully perused the matter on record and documents filed on behalf of the OP number
Plus
1,
the decision cited by OP.
Lordship.
Series
It
the
appears to me from the
insurance
exhibit A
certificate.
series that one insurance certificate was issued on behalf of the opposite party number 1 after accepting the check from him, but as the check was dishonored for insufficiency of fund, OP number 2 cancelled the insurance certificate and then informed that regarding such certificate. This is what my lord is asking again and again.
And
And the answer is no.
And they informed regarding cancellation.
Lordship.
In spite of that, relying upon settled principle.
And your lordship will get this relevance at page number 23, my lord. May I invite my lord to
It
page?
is saying the subsequent cancellation of policy.
Lordship. Yes. Only after the dishonor, my lord.
Anyway, the court came to a finding
Court came to a finding.
that the check was dishonored and the cancellation of policy was intimated.
Lordship. The finding is there. The finding is
Finding
not
is there. Now, whatever we want to submit, you submit.
And this finding is based on the deposition, my lord, exact, my lord, evidence being made.
There, you see,
Lordship.
these findings is not under challenge
I'm
by the
grateful to
vehicle
you,
owner.
I'm obliged.
My lord, kindly see the lower court report.
Yes.
Lower court report.
No, you see, I'll go by the findings of the learned trial judge. I will not upset that findings. Because you see, the vehicle owner has not challenged. The award, if it goes, it will go against the vehicle owner. Now, the vehicle owner
Did not receive the.
No. Whatever it is,
Sir, what
whatever on the
decision of
basis.
Supreme Court. What is the decision of the Supreme Court?
See,
Knowledge is there.
The
Without
trial court has
knowledge, how
come to
can-
the findings that he has knowledge. Anyway, whatever point you have to submit with regard to law.
That is from the AD card. It was not sharpened upon the OP1.
So, what is the deposition? Let us see that OP
Based
number.
on AD card, it is.
No, let us see the deposition.
Kindly see.
Page 23, your lordship will kindly come to.
Deposition may be wrong, but the documents will say.
No, let us see.
Documents will speak itself. If the deposition says no,
The
but the
question
document says that it is yes.
The question is,
Documents
you see,
will go.
these points could have been challenged, okay? Because so far the observation of the learned trial judge is concerned, the learned trial judge observed that yes, the insurance company is liable to pay and then recover it from the vehicle owners, okay? Now, as because the insurance company is liable to pay, but that liberty is not granted from to.
I also admitted that check was dishonored.
Okay,
I
now
also
the-
admitted.
Now, you cannot have any knowledge with regard to that. It is the vehicle owner who will have a knowledge. How can you have?
Can have had no knowledge.
How can you say that? The
That
vehicle
is the
owner.
documents. That is the documents say.
The vehicle owner has not come.
From where from the evidence will. Where from the
Question is,
evidence
you
will
see, you cannot have the knowledge as to whether the vehicle owner has received or not. It is for the vehicle owner to come and say whether he has received or not. And if the court is satisfied that yes, the vehicle owner has received, the court has come to a findings. That findings is not challenged by the vehicle owner.
That's why the insurance company came.
And you have also, it is not even challenged by the claimant also. So now how can you?
That's why came before your lordships.
Insurance company wanted
exoneration.
Not of check.
No. Go by the findings. Either totally exonerate the insurance company as per the decision or grant them the liberty to recover.
But in order to solve the matter, what knowledge is required in any case.
So the trial court held that knowledge is there. No, this court cannot go in with regard to that findings now. Because there is no challenge by the vehicle owner, nor there is a challenge by the claimant. So no question of going into that. So with regard to points of law, I shall consider.
All right.
Lord will submit it and notes, my lord.
Anyway, let him complete.
My lord, the decision. This is decision of the honor issue. I have already given my lord.
This is United India.
2012 SEJ 1307.
You see,
1307, my lord.
Court came to a findings, okay, that is not under challenge by either the vehicle owner or by the claimant, because it is because the you see, insurance company is not totally exonerated. They are granted, they are directed to pay. Only one line is not there, right to recover. Okay, so the claimant cannot be aggrieved. Assuming the claimant is aggrieved, claimant has not challenged that the findings. No appeal by the claimant, no appeal by the vehicle owner. So whatever is there, that this appeal court has to follow that.
But the decisions is in my favor.
Yes, the decisions are to be considered.
Yes.
However, it is applicable.
Yes. এটা লাগবে না, 2008 লাগবে না, এটা 2008 লাগবে না। এটা দেওয়া যাবে না।
করিয়ে তারপর এখন এসে হচ্ছে দাদা কি করো
পায়ে লাগছে, দিচ্ছি দিচ্ছি, এটা তো বললাম দেখিয়ে এটাও দেখিয়েছি, এটাও দেখিয়েছি।
In the instant case, I
Especially fixed, time was taken to give reply to
in
my
the
three
instant case, I believe no interest
Another
is awarded.
decision of the
Lordship.
No interest is awarded except on default.
In excess of default. Lordship, yes, no
So
interest
anyway,
awarded.
there is no challenge with regard to that.
My lord,
No, my lord, I am saying, Lord, I want, my lord, there is no challenge with regard to that, and my lord,
Interest
on
by
my
by
part,
any-
I
by any
want,
person.
on my part, I want absolute exoneration, my lord. My lord, today, my lord, standing
My
before
lord.
your lordship, hunting for the judgment after getting the matter adjourned when I concluded on his request, my lord, I don't know what kind of submission is being made here.
Anyway, what is the next judgment?
backbiting is very dangerous.
Judgment down, how much?
No. Check given by insured Kesor Bhai versus Afsar Ali. My lord, this is it.
So the reference to please bolo.
Kesor Bhai versus Afsar Ali. 2011 SK 2023.
Madhya Pradesh.
That dishonor of check, policy of cancellation, liability insurance company check given by insured towards premium was dishonored.
Yes, which
Insurance
page?
company sent a registered letter to the owner
Page.
intimating about an cancellation of policy, but it was received back unsubscribed. Witness of the insurance deposed that the post office gave intimation to insured about registered letter. Insured did not come to post office to collect the same, but the insurance company failed to prove that fact. No evidence indicating that owner had knowledge about cancellation of policy. What I am submitting, my lord. No evidence indicating that owner had knowledge about cancellation of policy.
Yes, so if owner does not have knowledge,
Yes, whether
the owner cannot be made
tribunal
liable.
Intimation, whether tribunal justified in for presuming that the fact of dishonor of check was within the knowledge of the owner and exempted the insurance company from hell no, insurance company is liable.
That is paragraph?
Paragraph 15, 16, 17,
15,
18.
16.
One after another. Earlier two decisions of the Supreme Court, same thing has happened. In this case also, kindly, my lord, first 1998, 123 Supreme Court, Oriental versus Indrajit Kaur. My lord, kindly see para 3. Para 3.
Yes.
Acha, I have already given. 1998 SEJ 123.
1989.
1998, my lord.
98.
98 SEJ 123. 3 judges bench decision.
Yes, 1998.
Patient.
Indrajit Kaur.
Yes, ma'am. Kindly go through para 3. In this case also, for purpose of appeal, therefore, very few facts are relevant. Here the insurance company came to the before the Supreme Court. My lord, very few facts are relevant. A bus met with an accident, its policy of insurance was issued by the appellant on 30/11/89. The premium for the policy was paid by check. The check was dishonored. A letter stating that it had been dishonored by sent by the appellant to insured 23/1 next year after 3 months. The letter claimed that as the check had not been encashed, the premium of policy had not been received, and therefore the appellant was not at risk. The premium was paid in cash on auto. In the meantime, 9,490. So after the accident, the premium was paid in this case.
Where, which page?
Page 124.
124.
Second page. Para 3, my lord.
Para 3, yes, a refund
Para
of premium which may be.
Yes. So accident was occurred on 9,490 and the premium paid on cash 2,590 after the accident. So in this case, in the meantime, on the bus collided the truck whose driver was died. The truck driver's widow and etc. That the appellant denied the claim, asserting that under the terms of 64B insurance, no risk was assumed by an insurer unless the premium paid on had received on advance. The motor accident claims tribunal rejected the appellant's contention and awarded the claimants of rupees atho with interest. Now it was challenged by the insurance company, and in this case also, Supreme Court dismissed the appeal, and circumstances, the insurance company directed the insurance company to pay the money. So this is after the accident insurance also. In this case also insurance company.
So in this case also intimation was made after the accident.
Yes.
In this case, intimation was made after the accident.
Which case?
In this instant case.
No.
Much before the accident.
So it is intimation is given before the accident.
Yes, yes. It's a different milord, it's absolutely on different
But
footing.
the fact remains that
I'm not in Indrajit.
Anyhow, the third party's insurance company will have to pay in case of third party.
No,
Because
Sunita is
contract-
very clear. Not.
Again, you will say in my case.
Sunita is
When
very
I
clear.
am saying that you take it.
2025 milord.
Employer, don't say like this.
Anyway. With
No, no,
regard
no.
to the
2025 milord, the last
Yes,
Supreme
this
Court.
is-
No, no.
So this is the 3-judge bench, okay?
Yes. And another the judgment I have given the constitution bench judgment, but the earlier decision will prevail. So my decision is the earlier decision. Same point. Then, and here also clearly speaks about the Supreme Court. Already I have shown, my lord, that the Supreme Court diluted the point. I have decision. I have saying, my lord. The 18, para 18. Eh? My lord, para 18, what I have stated, this is very important. This
Which
is
para?
Supreme Court decision, United India versus Lakshmana. Here also, Supreme Court did not accept the view. It is very, very important in this case. 18, para 18, my lord. What I have stated.
Para 18 of this Indrajit Kaur.
Para 18 of para 18 2012 SEJ 1307.
अरे नाम बोलो लक्ष्मण
Supreme Court and Lux Mama. United India versus Lux Mama.
Yes.
Here kindly see the specific, we find that the judges find it hard to accept the submission of learned counsel for the insurer, that the 3 judges bench of decision in Indrajit Kaur, what I have already told, has been diluted by the subsequent decision of Simamasa Dadappa and Simamasa Dadappa. So here's explained what the two decisions said. So this is very vital. Supreme Court did not accept. Supreme Court depend upon the 1988 SEJ 123, 3 judges judgment. Moreover, the 5 judges judgment of Constitution Bench also earlier decision. This is all of my submission.
Yes.
Another thing, it will be 5 lakhs because the 163 a case.
So there is no cross objection.
Nothing, but the tribunal can,
but file cross objection.
judge can do it what is just and fair.
Yes. So when the compensation claim,
From the judgment of the Supreme Court, where the just and fair,
yes,
that will be the.
Now the question is, nobody is claiming what is just and
no
fair.
claim. In this case, also Supreme Court says that what is just and
yes,
will be
the
awarded.
tribunal will award that. Okay, at the very first instance. Suppose the claim amount is 5 lakh, the tribunal considers 10 lakh. Yes, that will be awarded.
No, in this
but one particular forum has decided your issue. Okay. Now, unless there is no challenge with regard to that. So why?
All right.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates. Anyway, let this matter appear on 21 8 2026 at 10:30 AM for filing written notes of arguments. Day after tomorrow?
I can do it.
Hey,
time ta kota
Obliged, your lordship. Extremely grateful.
Doctor, you are appearing on behalf of the applicant.
My lord, I am for the respondent, my lord. I am praying for not today, my lord. I have been led by Mr. Ruti Rai, but due to sad demise of his close relative, he could not attend this court.
Is it appearing for the first time?
No, I am appearing. I am led by Advocate Dhananjay Banerjee.
Was this matter heard earlier?
Yes, partly heard, your lordship, and it is 2 times they have taken up time, and your lordship can allow to file the written notes of argument with some.
No, that hearing was concluded.
No, partly concluded, your lordship.
Okay. Then let it appear. Yes, record an order. Learned advocate for the appellant is present. Prayer for time is made on behalf
I am
of
for the respondent.
on behalf of learned advocate for the respondent. The matter stands adjourned till 17/9/2026 at কখন টাইমিংসটা দেখুন একটু 2 PM না 3 PM?
2 PM, your lordship. 9.
Hmm? 2 PM, তো 2 PM ই থাক। 3 PM ও আছে। তাহলে এদিকে দেখুন সকাল 12টার সময়। ওকে 12 PM.
Lordship. Obliged. Get it.
I am for the respondent.
Yes. Yes, this matter was heard earlier.
Yes, my lord. Where Mr. Chatterjee was making submission, my lord. That same matter, my lord.
So he has not concluded.
But he has not concluded, my lord. He was placing, my lord, the appeal court judgment, my lord, and he has reached, my lord, till page 29, my lord. My lord, may I just continue?
Yes, he's coming.
He's coming.
First of all, congratulations to your lordship.
Okay, thank you. Yes, what do you say?
Continue.
No.
Oh, your is a writ matter, 12.
Next matter. So I'll wait, my lord. If this doesn't continue till 4:30, I'll wait.
Yes, Mr. Chatterjee will continue, take rest of the day.
Don't think so, my lord, but
But he will conclude today.
Chakraborty, my lord, is a busy lawyer, so
No, but he will conclude today.
the judgments, my lord, I'll finish off with the pleadings and the law, the judgments I'll
That
cite
is
on.
written notes of arguments.
It's ready. Ready. তোর মামলা বলে এগুলো করছে না তোর মামলা on the last occasion we were I was showing your lordship the the judgment, my lord, of the trial court, and I was showing your lordship why it was perverse. My lord, the judgment, my lord, was at page অনেকগুলো জিনিস ঢুকে গেছে, huh? 29, but we had, my lord, traveled way beyond that. On my আবার হওয়া
পেপার বুক মানে কম্পাইলেশন দিয়েছে পেপার বুকটা
yes হ্যাঁ ওটা ওখানেই ছিল. My lord, we've come to, my lord, page
No,
29.
because you see, you were addressing on this particular points of law regarding Order 21 ruled 76. 72. That
And why is it different, my lord, from Order 21, Rule 90?
yes, that is the what the findings
That
of
is
the
the
learned
finding,
judge.
the court went on the finding of Order 21, Rule 92. And I am on, my lord, saying that my case doesn't fall under Order 21, Rule 92 at all.
Because you see, if you are able to show that suit is maintainable,
Yes,
then you have a very good case.
Absolutely.
First of all, let us see the propositions of law.
My lord.
Thereafter,
My lord. It's
because you
there
see,
in
there
the
are
paper.
several facts.
Yes, my lord.
Those dues and when it became
Yes,
matured.
those facts, my lord, your
all
lordship
these
has
things.
now,
So many times you have argued that.
not required at all. Your lordship,
So
my lord,
let us-
understands
let
that.
us see
Just
the-
once looks at the final page, my lord, of the order of the judgment of the trial court, and then I'll take your lordship,
Yes,
my lord, to
come.
the
Yes, page.
29. We had ended on the last occasion. My lord, kindly have a look at 30 bottom.
Yes.
Rather, my lord, it's my fault. It is better that for the sake of continuation, my lord takes up from 28 bottom. Be it further mentioned that apart from the limitation period, my lord, kindly got that?
Page 30, paper book.
Page 28, paper book.
Page 28, paper book. Yes.
Be it further, that's the last paragraph.
Yes.
Be it further mentioned that apart from the limitation period prescribed for filing objection for setting aside sale under Order 21, Rule 89, 1991 of the Civil Procedure Code being 60 days, extended from 30 days, the limitation period to file an application for setting aside sale in execution of a degree, including an application by a judgment debtor, is also 60 days. So the court was considering, my lord, only Order 21, Rule 90, 89, 90, and 91. So my basic submission before your lordship was, when a degree holder is purchasing the property, Order 21, Rule 72 applies and not 91. Now, under 91, my lord, I will show your lordship a decision on that. There is a bar saying that no suit will lie. Now, the Supreme Court, my lord, in a very recent decision, my lord, has said, if your lordship sees 91.3, if I'm not mistaken.
Order 21, Rule 91.
91.3. There is a bar that there will be no suit if there was an application under Order 21, Rule 90.
Order
Subject to my
21, Rule 91.
Yes.
Yes. The purchaser, Order 21, Rule 91.
91.
The purchaser at any such sale in execution of a decree may apply to the court
Apply
to set
to the
aside
court.
the sale.
Ah.
This is for the purchaser.
Exactly.
On the ground that the judgment debtor has no sellable interest in the
Exactly.
property sold.
Exactly. for the purchaser. I'm so grateful to your lordship.
Yes.
This is where the perversity, my lord, comes on the face of the record.
It's not the judgment debtor.
Ah,
So what
and-
is the remedy of the judgment debtor?
that's 72.
72.
Here, my lord, is a case of, yes, judgment debtor 72. My lord, why I wanted your lordship to, my lord, see this is to show, my lord, the perversity, my lord, in the judgment itself.
Yes.
Because, my lord,
not
what
to be-
they were really considering was a provision which doesn't apply to me. Have a look at 72.3.
Yes, on the application, purchase himself
Yes.
or through another person.
This is our case. This is our
The
situation.
court may, if it thinks fit on the application of the judgment debtor, sell may be of order set aside the sell and the cost of such. Now this is the remedy provided under the statute.
Correct. Absolutely.
So
This is an
okay.
enabling provision when, my lord, the execution is pending.
Now where is that?
My lord, order 21 comes to an end, my lord, if the execution goes. I can't go back, my lord, to a suit which is already off.
No, you see, if by misleading the court an execution is put
That's
to
why I'm
an
saying
end,
where the suit lies.
no, that is why in such a provision, in such a case, if your suit is maintainable, then you have a very good case.
Absolutely. I'll show your
That's the
lordship.
thing you have to show.
Absolutely. Now, why I'm saying, my lord, whether your lordship would decide or, my lord, the courts below will have to decide on 72, that's a different aspect. What I am trying to show your lordship today is, my lord, that this aspect was never considered. This aspect, this provision was never considered by the courts below.
This provision is there. Okay,
It's there.
but you have
Not considered is my lord, an example of perversity. So this is one aspect. Whether my suit is maintainable, I will satisfy your lordship on that. The first argument, my lord, with respect to this is on a question of law. Order 21, Rule 72, my lord, is a question which is to be decided, my lord, by way of an application.
yes.
Now, when does this lie? In my respectful submission, my lord, if the execution proceeding is pending, it lies then. Once the execution proceeding, my lord, is off behind my back, is off, then, my lord, the suit lies, and that's what the Supreme Court is saying. My lord, if a question of fraud, if I can show your lordship that the fraud has happened on the face of record by, not by Mr. Mukherjee's client, but by his predecessor, then, my lord, the limitation starts from the day when the fraud is unraveled.
Yes, that is there.
So there is no question of, my lord, Article 127 coming into play here.
Yes.
The learned judge has gone on the principle of 127. My lord, I have in the previous, my lord, submissions, I have told your lordship what was the, my lord, the fraud which is on the face of record. What fraud had happened and how, my lord, I was, my lord, deprived of my property or to, my lord, even protect my property, that your lordship has seen, my lord, from the records which has already been placed before your lordship.
Now, what was the two propositions of law framed?
Yes. Now for that, my
Which page?
yes, kindly comes to the paper book right at the end. Written notes of argument are there.
Page.
I'll give you a lordship. Just give me a second. The questions of law, my lord, were framed by the division bench in, that's there, my lord, in, yes, 147. 147. একটু ফলো করতে কি অসুবিধা হয়?
Yes.
লর্ডশিপ যেটা চাইছেন সেটা ফলো করতে কি অসুবিধা? Whether the appellate court committed a substantial error of law in not holding, এটা কি হলো? কি রে? In not holding that the second money execution case, this your lordship has already seen. My lord, I've argued this before your lordship on multiple occasions. Then comes to second one, error of law in not holding that the order of attachment before judgment passed in sunset lost its force after dismissal of the first money execution. This also your lordship has seen, my lord. Appellate court committed an error in holding that the suit for setting aside the auction sale and sale issued in such and such was barred by law. This is what we are on, which your lordship is, my lord, deciding basically. Number 3. So if I'm able to show, which fell from your lordship right now, my lord, that if I succeed in 3, then, my lord, I have a very good case.
Yes.
Absolutely. So my endeavor, my lord, would be before your lordship to show, my lord, that suit is maintainable.
Setting aside, actually, you see, auction sale is by that provision. Okay.
My
Now, according to you, as the execution case is disposed, there is
there is no other
now
scope that I
only
will
thing
go
is
back.
this: if suit is maintainable on this ground 3,
Absolutely.
then
Then,
you
my
have
lord,
a very
everything
good
falls
case.
into place. Now, my lord, takes it for granted. If your lordship feels, my lord, this is an alternative submission, the earlier submission I will make. Now, which court, my lord, with the suit would go? The court would go, my lord, the suit would happen in the place where the execution has happened. Same court. My lord, in a very recent decision, my lord, if your lordship has seen it in the commercial court, what was happening was a suit was filed, my lord, not in the commercial court, but in the regular court. A point is taken under Order 7, Rule 10 or Rule 11 that this court can't hear it because it has to be heard by the commercial court. Then courts mechanically started saying that the suit is not maintainable, go away. Supreme Court has now said that if it is to be heard by the same court, then there is no question of no question of setting aside the entire thing or setting aside whatever. It will just be converted to that. Nothing beyond that, because it will be heard by the same court.
The court which has passed the decree.
Yes. So hyper-technical view, my lord, in a question where, my lord, there is a fraud which is on record. On the face of it, it's there. My lord, in my respectful submission, court would not look into that. That's my second limb of my argument. I'll come back to the my lord, the first limb. Now sees your lordship has framed another substantial
That is
question.
4 probably.
Number 5.
5,
which is obviously not there, my lord, in this order.
It must be in the
Your
record.
lordship, my lord, made that we've given there in the written notes. Whether the learned trial court and the appellate court erred in not considering the issue of fraud in arriving at the findings. There was no, my lord, whisper. Your lordship has seen, my lord, the judgment, the trial court's judgment. Your lordship has seen that they have gone on a different footing altogether. They say about Order 21, Rule 89, 1991, which according to me is not even the provision which is, my lord, required to be seen by the court in the facts and circumstances of our case. And then came into the question of Article 127 and then says, my lord, 92, my lord, is a bar. My lord, kindly satisfies my lord self with the provision first, looks to Order 21, Rule 92 first. Satisfies my lord self.
Yes, Order 21.
Where no, lordship, can you got that, right? Where no application is made under 89, 90, 91. My lord, let us see what is 89, 90 and 91. If your lordship comes back, 89, I'm sure, my lord, it's not, I don't want to, my lord, waste your lordship's time. It's not on that. It's about, my lord, set aside sale on deposit. When the, my lord, the judgment letter goes and deposits. 90, set aside a sale on ground of irregularity or fraud. Where any immovable property has been sold in execution of a degree, the degree holder or the purchaser or any other person entitled to share in a relatable distribution of assets or whose interests are affected by sale may apply to the court to set aside the sale on the ground of material irregularity.
This is with regards to category of persons who are entitled.
So grateful to your
90,
lordship.
that is there.
Don't come in there.
And regarding 80, the category of the persons can maintain that application.
So grateful to your lordship.
So this is also.
I am not coming in that category at all.
So 89 is any person claiming an interest in the property.
Sale. That is 89. 90, my lord, is a human who is a degree holder or the purchaser or any other person entitled to a share.
No, 89 is any person having interest in the property.
Yes, my lord. That is on deposit. That's on deposit. Where immovable property has been sold in execution of degree, any person claiming an interest in the property sold at the time of the sale or at the time of making the application or acting for on the interest of such person may apply to have the sale set aside on his depositing in court for payment to the purchaser a sum equal to 5% of the purchase money. So I am not even getting into that. I am saying I didn't even have to pay Mr. Mukherjee's predecessor. So my entire challenge to the sale is on 72. And kindly sees what's happening here. The first execution goes, second execution is not ripe. They file that application, say that it's within 2 years, so I don't need to give notice, sold. This is the small fact before your lordship. And sold to whom? Sold to the decree holder. So 72 applies here. So for a debt of 300 rupees, he is buying a property by paying about 1 lakh or something. That's what Mr. Mukherjee has paid. And the degree holder has paid something about probably 30,000 or something. And what is the schedule of the property? Your lordship has seen. Acres of property with trees, with the vegetable growing, with a farm going on there, with a poultry farm, everything there.
Now the possession is also with the
me.
plaintiff. That is the observation of the
that is admitted fact
of the trial judge.
My lord.
Now the
Because
question of
trial
equity also
judge-
comes, you see, regarding.
Absolutely.
Let us see with regard to equity, what can be done also.
So grateful to your lordship. So grateful to your lordship. Now, the trial judge appointed a special officer under Order 26 Rule 9 to go and see who's in possession. Because all throughout, they have said that we have obtained possession. If your lordship remembers that exhibit which said that the bailiff said that possession was handed over. It is not the case that I went out and came back. No. He purchased the property sometimes in 2001 or something.
Without getting the possession.
Absolutely. Absolutely. So during the moment he came to the property saying that this is my property, it's when I discovered that this has happened behind my back. I had no knowledge about this. And nobody has shown that I had knowledge.
That is the possession is there. That is
My
the
lord,
finding.
absolutely. So grateful. Then sees the appellate court. It goes by the same footing, in the same footing.
Apart from written statement or our citizenship
সেটার মধ্যে আসছি আবার পরে আসছি এটা জাজমেন্টে আছে একটা কোথায় জাজমেন্টে আছে অ্যাপিল কোর্টে জাজমেন্টে আছে the appeal court judgment, may I just place it before your lordship, not the entire, because the facts your lordship know by heart.
Yes, that is page.
It starts from page 80. What? Paper boy hai. No, I to put it. Kindly comes to page 58. Earlier, a lot of things have been said. Your lordship need not trouble my lord self. Point number 1. At 58. This becomes a little bit interesting and important as well. Your lordship forgets about the points which have been framed, 58 to 59. Your lordship will not find anywhere, my lord, with respect to Order 21, Rule 72, anywhere. Comes back to, my lord, the decision with reasons. Your lordship will doesn't trouble my lord self. Kindly turns to 61. Small snippets I'll show your lordship without wasting my lord's time. 61, third paragraph. He further deposed that his father Dhirendranath Boito paid the rest decretal amount to son of Ramchandra Mukhopadhyay, and as a result, the receipt was also issued by Lokhi Prasad Mukhopadhyay, the son of Ramchandra. He further deposed, your lordship need not trouble my lord self, Lord, how much is the amount? Your Lordship will find at 62. Sees last but one paragraph. He further deposed that it. Lordship, have you got it?
He further deposed that no statutory.
Just after that.
Okay, for that it was absurd at only 365.
The suit property admeasuring 6.25 bighas was, Lordship was talking about prejudice here, or my lord, the equity here.
Yes, possession and with regard to some equitable relief. That is the thing which may be considered.
Absolutely.
Although second appeal is purely on the
Question of
substantial
law,
question of
but
law.
here
Equity in a civil matter. Lord.
Yes.
Not there's no equity in a civil matter. It is all about not in the writ
No,
jurisdiction.
no,
your
you
lordship
see,
may.
you see, in so
But your
many
lordship
civil.
here has to decide on
No,
the basis
in-
of not the
under
substantial
the
question
in
of-
different under specific relief act, that is under the equitable principles. Entire
But
specific
that is,
relief act.
that is not the suit here. That is not the suit here.
there is no suit on equity. Equity comes in, it's vested with
No, no, suit on you see specific relief.
Absolutely.
Many things are based on that
My
equitable
lord,
principle.
all laws, the basis of all laws is equity. Basis
Because where
from
common law is deficient, equity has a role to play.
Absolutely. Absolutely. Then, if your lordship kindly comes down, I'm not showing your lordship the entire. Kindly see 64. My lord, equity is something, my lord, which is embedded in every court of law. Like 151, that is, my lord, the courts are, it only saves the inherent powers. It doesn't grant, because the moment you are a court, you have inherent powers. It only saves the inherent powers. If your lordship sees below 151, it is a saving provision. It's not an enabling provision. Moment you are a court, you are vested with inherent powers. The same way is with equity. Then, Milord, I'll come to equity later, Milord. That's a different aspect. Sees, Milord, the second paragraph. In his evidence, PW1 adduced 44 rent receipts, which were collectively marked as Exhibit 1. Though after objection, certified copies of Porcha, EA Act Settlement Record of Rights, which your lordship has seen, corresponding to Khotian number 24, Khotian number 710, Khotian number 360, and Khotian numbers 203, which was marked as Exhibit 2. Certified copy of LR Porcha corresponding to Khotian number 327, which was marked as Exhibit 3. 6 original electric bills, which were collectively marked as Exhibit 4. A certified copy of the order passed in money execution number such and such, which was marked as Exhibit 5. The money receipt showing payment of 950 by Dhirendranath Boitto since deceased to the defendant number 1, Lokhi Prasad Mukhopadhyay, which was marked as Exhibit 6. Though after objection, and last, the certified copy of order in M case number such and such, along with attested copy of the will, which were collectively marked as Exhibit 7. So even the payment of money, my lord, that was also exhibited. Then, my lord, if your lordship turns down, I am not troubling your lordship with the entire, so that, my lord, I don't waste my lord's time. Kindly, my lord, goes down right at the end. All the, my lord, the depositions have been, my lord, considered. Comes to, my lord, page 70. This is from the deposition of Mr. Mukherjee's client. He said everything, my lord, and he has also said this. He also admitted that the defendant number 1, Lokhi Prasad Mukhopadhyay, filed written statement in this case. Lokhi Prasad Mukhopadhyay, my lord, is the predecessor of Mr. Mukherjee. He also admitted that he did not know if attachment of property before judgment was made in money suit number such and such. He also admitted in his cross-examination that he did not have any knowledge about any sale certificate. This is I'm on. So what is the defense proving in my respectful submission? May I ask this question to myself? Your lordship remembers, my lord, that there is no deed in favor of Mr. Mukherjee's predecessor.
No registered deed.
No registered deed. My lord, even in DRT proceedings, the sale certificate needs to be registered. Then, that he did not know anything about money suit number such and such, anything about money execution case number such and such, and money execution case number 63 of 1964. So the only defense witness knows nothing about, my lord, what has happened in 63 and 64. So whatever I am saying, my lord, there is no rebuttal to that. Because the predecessor,
the defendant did not examine the predecessor as his witness.
No. He ought to have.
You examine him as a,
Absolutely, my lord. Because he has no personal knowledge. Justice Sema's judgment, even if he is, my lord, a power of attorney, he can only depose to as much as he knows, not beyond that. And if you are a power of attorney, he can only depose to what you have been told by the executor. Nothing beyond that. So whatever is happening in 63, 64, my lord, he has no knowledge. Then, in his cross-examination, he was put several suggestions. DW2 is Prangopal Chakraborty, who happens to be the deed writer of the sale deed Sadansa, registered before. My lord, your lordship need not trouble. My lord said that registration is there. Kindly have a look at my possession, 71, last but one paragraph. During his cross-examination on 8th of October 2015, he stated that Kumudini and Devdas, that's my clients, my lord, were residing in the house situated at Mondalpara. That is their admission. সেটা লাস্টে গিয়ে দেখাবো very well. I'll show them. My lord, at this, let us look at the trial court's judgment at page 31. It might be of some relevance to your lordship.
yes.
Is 31, no?
30 last paragraph.
30 তে যাই চট করে। Looks to me 30 bottom. My lord, kindly got that?
Yes.
In this respect, be it mentioned, the defendant number 1 did not contest the suit after filing written statement. In his written statement, admitted the possession of the plaintiff and his family in the residential house situated over the suit properties, and stated that the original plaintiff, Dhirendranath Boiddo, had requested to permit him to temporarily reside in the residential house situated in the suit property, and thereafter Dhirendranath did not deliver possession of the said residential house in his favor in spite of repeated requests, and ultimately he sold the suit property to the defendant number 3, Sudhir Kumar Sarkar. The only contesting defendant number 3 in his written statement also admitted the possession of the plaintiffs over the residential house situated in the suit schedule properties, and claimed that except the residential house, he has possession over the rest of the properties. It further appears that a separate, this is important, it further appears that a separate eviction suit being number 244 of 1988 was also instituted by the defendant number 3 against the plaintiffs, and the said suit was being heard analogously along with this suit until it was abated on failure to substitute the heirs or sole defendant Dhirendranath Boiddo with time. In such circumstances, in view of the certified copies of the orders in such and such, this court is unable to hold proper title of the original sole plaintiff, Dhirendranath Boiddo, over the suit schedule properties, including the residential. So even for eviction, my lord, they've given a go-by to that. I do not... So whichever way it happens, my lord, my possession is protected for the moment.
Yes, that is there.
The suit has gone. Now, my lord, comes back to where I was at page, my lord, 71. 71 is ছিলাম? Yes. Now, I've showed your lordship that. Again, I need not, my lord, trouble my lord self with the entire, because that is these are facts which your lordship has already seen. Kindly see 78. See the second paragraph. The defendant number 1, my lord, kindly got it. Defendant number 1, though filed a written statement denying each and every allegation averred in the plaint, but ultimately did not contest the suit. Then, skipping over the next paragraph, the sole contention of the defendant respondent number 1 was that plaintiff appellant's predecessor, now deceased, Dhirendranath, in order to correct errors committed by him and also to remove discrepancies and omissions of the judgment and degree of the money suit number such and such, and the order of execution case being money execution number such and such, arising out of money suit being number such and such, file the present suit as a sole plaintiff claiming title to the suit property. কোথায় গেল রে? এটা বন্ধ হয়ে গেছে, এক সেকেন্ড দাঁড়া, বন্ধ হয়ে গেছে। Claiming title to the suit property after a long lapse of 2 decades, which was barred by limitation 2. Then, Milord, your lordship turns over 79. Just gives me a second, Milord. The problem with liquid text is at times it stops working.
Yes, now the question is, you see, the execution case was dismissed for part payment.
Yes.
But the said proceeding could not be said to be finally disposed of. But once it is dismissed,
it goes.
Whether it cannot be.
This is basic. I don't need to, Milord, even make my submissions on it. It's dismissed.
Dismissed means what remains to be passed in that.
Grateful. And I don't even know, Milord, if it's been said, they might make a submission that the cause of action for the second execution comes in only after default in the payment schedule. Could have happened. And that also, Milord, is not there. Within 20 days, the second execution was filed. Your lordship has marked that.
Now, that is the question. You see, the second appeal, as you know,
within the 4 corners of, Milord, the substantial questions of
all these things.
It's all, Milord, it all comes in, and in that number 3, if I can show perversity on the face of record, your lordship has ample power on second appeal. Milord, it is second appeal is not a rubber stamp court. Second appeal, Milord, is a court which sees if there is perversity. Milord, there are 3 occasions. Right from 93 Calcutta, Milord, that's a 7 judges bench decision. 5 judges bench decision. If an order of degree is based on no evidence, if a degree is based on wrong interpretation of evidence, if a degree is based on, Milord, no evidence, if it's a degree based on conception of law which is wrong, second appeal lies. So if I am showing your lordship, Milord, that the entire judgment of both courts is wrong because they've applied wrong provisions of law. Wrong provisions of law. They have forgotten, Milord, that the Order 21 Rule 89/1991 is not where I am on. Moment Milord, the degree holder buys the property, Milord, from that the auction, 72 comes in. So my challenge is on that provision, not on.
You are protected under your remedy is 72.
Yes, that's a enabling provision.
But you have filed a suit.
Milord, like there is a bar in, Milord, filing a suit. So that's why Justice Pardiwala judgment will be a little bit more.
Yes, if the suit is expressly barred.
That's what I'm saying. That's 92. There is an express bar.
Yes.
In 72, your lordship will not see that bar. In 72, Milord, your lordship will not see that bar. Now, what is barred under 92 is explained by Justice Pardiwala. Milord, what is barred? A person who has filed a 92 application praying for setting aside, fails in that, and then goes and files a suit, his, Milord, suit is barred by res judicata. That's what the Supreme Court is saying. And it's as fell from your lordship, it's a quality of persons who can file under 92. Under 89, under 90, under 91.
Those categories.
Those categories come into play. Not me. Moment, Milord, he buys it. The degree holder buys it, Milord, in auction. 72 comes in. I fall under that category. So your lordship will not see, Milord, that even the learned judge has ever even looked into it. And kindly keeps in mind, Milord, 77 Supreme Court, page 5. A question of law, if it goes to the root of the matter, Milord, it can be taken up for the first time even before the Supreme Court. This is a question of law which goes to the root of the matter.
Yes.
Then, Milord, your lordship did not again.
Regarding that position, that.
Admitted
that
by
there is
him,
a findings.
my lord. Finding admitted.
Now
In
regarding
deposit, even by him, not just my lord, by his predecessor, even by him, he himself has said, my lord, that I am in possession.
and the second thing is this, the court came to a findings. Oh, this is
Finding.
yes, no, this is execution case is dismissed,
Yes,
but not finally disposed
not
of.
finally disposed of. This is again, my lord, oxymoronical, but that's হ্যাঁ সেটা পরে রিটেন নোটস পরে বলবো হ্যাঁ হ্যাঁ না, সেই আর্গুমেন্ট অলরেডি হয়ে গেছে, সেই আর্গুমেন্ট আবার বেকার আবার করে করার দরকার নেই। Mr. Mukherjee wants me to remind your lordship about the installments and the
Very well, you delete in your written notes.
yes, it's all there in the written notes. It's all there. Then, my lord, if your lordship turns down to 82, kindly have a look at the second paragraph. The certified copy of the degree passed in money suit number 59 of 62 as filed by the defendants in this case reflects that degree was passed for rupees such and such. The judgment letter Dhirendranath Boiddo having not obeyed the degree, the plaintiff degree holder Ramchandra Mukhopadhyay had initiated money as such and such initially, but no bidder having not been available to bid for the sale, the said execution case was dismissed on part satisfaction of rupees 400 only. But I would say, after this finding, what fell from your lordship, my lord, is most important. Kindly sees why it was dismissed. This is a finding of court. This is the finding of court. Nobody was found. 400 rupees paid. Execution dismissed. What can I do? I go behind the doors. This is over. Should have been over, but wasn't over.
Execution case dismissed.
Yes. And why? The learned judge has found this. And this was, yes, in Milord 1964, this had happened. 8th April. We've dealt with that, Milord, in our written notes as well. I'll show you a lot of that once I finish. Then, Milord, kindly comes down to 83. First paragraph. The record reveals that the second execution case, being money execution case being number such and such, was filed on such and such, which was marked as Exhibit E. On close perusal of Exhibit E, it appears that Ramchandra Mukhopadhyay, the degree holder, filed the second execution case against the judgment debtor, Dhirendranath Boiddo, in connection with money suit number such and such. On a close scrutiny of it, it further appears that the degree holder Ramchandra Mukhopadhyay had properly disclosed in his application for execution that previously another execution case, being money execution case number such and such, had been filed by him in respect of degree passed in money suit number such and such, and the same had been dismissed on part satisfaction of the degree to the extent of 400. Thus, it appears that the degree holder of such and such, while applying of the second execution, did not conceal this and suppression the institution of the first execution proceeding, being proceeding which was registered and money execution case number such and such. This plays with the judge, below. If I tell the facts, it becomes sacrosanct. No, the law comes into play. This doesn't give him brownie points because he said something, my lord, which has happened. This is a matter of record. He had to say it. Then, my lord, kindly have a look at the next paragraph. Now, to reassess and evaluate the evidence of the parties to the suit, I pay my attention towards the oral and documentary evidences. My lord, your lordship need not trouble my lord self. All the evidences have been, my lord, put forward. The findings will start only later. '93. Need not trouble my lord self. It's on attachment. Sees 57, my lord, is at 94. Now sees the finding at 98.
Yes.
That being the settled law, the argument of the learned counsel for the appellant plaintiffs, in my considered view, has no legal force in view of the fact that no further attachment of the property in question was required even in the second execution atto, and as such the submission of the learned counsel for the appellant painted that the second money execution case number such and such, along with auction sale thereof, as also with the sale certificate, were procured by paying fraud by the degree holder. So fraud was pleaded and Milord even submitted them. Ramchandra Mukhopadhyay, since deceased, and also by his son Lokhi Prasad Mukhopadhyay, since deceased, in collusion and connivance with the process server of the learned executing court, were of mere allegation, but not being supported by the pleading in the instance suit such and such, nor by proving the alleged fraud by any documentary proof laid in evidence. Milord, fraud is on the court records. Milord, a fraud of this nature can't have a documentary proof. With a lot of respect to the learned appellate court, he can't be, Milord, a person.
Court record means the court which has passed the decree.
Yes,
but if you have not moved that particular court, those records are not there because that particular court in that particular application
was there. Entire record of the money execution case is an exhibit. That's why I showed your lordship, Milord, the entire record of the money execution case, Milord, is an exhibit. It's all here before your lordship.
Okay.
That's why I showed your lordship that part of the judgment, Milord, which records the exhibits. The order, the way the second execution case has been filed, everything is an exhibit. So he could not, there is nothing beyond that. The fraud, Milord, is on the records of the court. And I am, Milord, with a lot of, Milord, conviction, I say, Milord, that this is a fraud on court itself.
But the trial court said it is not a fraud.
Exactly. The second execution case being filed behind the back, that itself is, Milord, one of the examples of biggest fraud that can happen. And then say what? Say that it's within 2 years, I don't need to serve. And then sell off my property for 300.
Even if 2 years, you are not required to serve, but
when sale happens.
But the fair, but the genuine
Milord, what
facts
happens,
are to be stated, assuming it is not served also.
Absolutely, Milord. Now what happens is, in a degree which doesn't have terms, I can still understand. This is a degree, Milord, on compromise, which has terms which need to be, Milord, fulfilled.
So that was not.
I could have, if I had known that there is a second execution, I would have gone and told the court that, look here, this is what it is. I would have explained to the court that, look here, don't sell my property because this is where his cause of action to file the second execution arrives. If a definite degree, my lord, say your lordship passes a degree for eviction, I understand. An eviction degree, there is no problem with it. Moment the bailiff comes, I get to know that there is an execution. If I have to do something, I will come to court in the executing court and file whatever I want to, my lord, 47s, order 21s, whatever it is. I get to know. The bailiff can't come and throw me out. There will be, my lord, some resistance if I have to, if I want to. Here is a situation, my lord, where again 300 rupees, it's there, my lord, on record. 300 rupees, he's selling off, my lord, a 6.5 bigger.
It's a question. If fraud is established, then
exactly, it's there. If the learned judge wants to keep his eyes shut, then the litigants will go nowhere, my lord. It's on record. Whatever fraud, that's on record.
Yes, but not being supported by the pleading in the instant suit.
Lord, may I ask this question?
Proving alleged fraud by documentary evidence.
May I ask this question to myself? What else can I prove, my lord, before your lordship? What else can I prove, my lord, before your lordship? May I ask this question to your lordship self and to myself, my lord, and my lord, for your lordship's kind consideration. I can't do anything beyond this. I can't procure, my lord, documents from here and there. Then, by any documentary proof laid in evidence, and I would like to go on ahead further by expressing my view that the pleading as made out in such and such is hit by Order 6, Rule 4 of the Code of Civil Procedure, which provides that in all cases in which the party pleading relies on any misrepresentations, fraud, breach of trust, willful default, or undue influence, and all other cases in which particulars may be necessary. So important is this line, in which particulars which may be necessary. My particulars are on record. Because this is the reason why nowadays, after the amendment of the Specific Relief Act, pleading is not necessary, my lord, to prove readiness and willingness. Is not required. Because we've stayed back in that primitive era where fraud, even though it's on record, I will have to plead, I will have to prove. We are moving ahead with that. It's absolutely right. Anything vague? Certainly not. Anything vague, anything, my lord, which is not true, I understand. Court records, my lord, can't be untrue. My lord, these are records of court from where I'm saying the fraud has come up.
Only thing you have to establish is the maintainability of your
Of
suit.
the suit. I will most certainly do that. But I want to, my lord, finish with this, my lord, so that I can be, my lord, I will be failing in my duty to show your lordship that the courts were not in the right direction while deciding, my lord, this suit. Then kindly comes down, after Order 6, Rule 4 is done, need not trouble myself, my lord, all the execution case documents, all have been discussed. It was there, my lord, on record. Sees 102, that is with respect to, my lord, the receipt. Then 103. Second paragraph. Thus, in view of the above,
Yes.
The entire dues according to the money suit such before institution of the second money execution case. আরে তখন তো আমাকে entire due দেওয়ার 4 বছর তো শেষই হয়নি।
এটা বলেছি যাচ্ছে। Lord, my learned friend is absolutely correct when he wants me to point out. Looks to the 101 last line. No document was also not filed by the plaintiff appellant in this case to show that the entire dues was paid by 4 yearly installments as decided in between them in Solenama on the basis of which.
Anyway, this is a factual aspect.
Factual aspect. Lordship has seen that. Kindly comes down, my lord. Your lordship will see Order 21, Rule 2 being discussed. I don't think, my lord, it's necessary for me to answer that. Sees 103. This is where, my lord, the learned appellate court is, my lord, getting into. Thus, in view of the above detailed discussions, it appears that the plaintiff appellants have failed to establish that they had satisfactorily repaid the entire decretal amount in favor of the degree holder, Ramchandra Mukhopadhyay or his heirs, and thus further to establish that Ramchandra had no legally enforceable reason to institute subsequent money execution case.
December 1965. 27 April 1964.
I'll just give you. This is where, my lord, the perversity on fact and on law, my lord, go ahead.
Yes.
My lord, your lordship needs to, my lord, look into that Solenama. When, my lord, was the time, my lord, his predecessor had any occasion to file the second one. As per us, the 4th installment was to be paid in the month of Ogran 1372, which corresponds to, my lord, 15th November to 15th December 65. The 4th one. And he has filed on 27th of April 1964.
So those issues were discussed regarding you paying off the date?
That was later. That was later. My lord, I am on a more fundamental issue. I am saying when you file the second execution case, it wasn't ripe on me to pay you the second or the third installment. And the entire thing, yes, and I had paid extra. That your lordship has seen. When I brush off, my lord, when I give your lordship this summary, I'll tell your lordship that. Even the 4th installment, my lord, was due only on 15th November to 15th December 1965. And he files the second execution case, my lord, on 27th of April 64. 64. No notice. Sale happens, he buys the property.
Regarding that notice, that may be a matter of right that 2 years, not more than 2 years.
Maybe a question of law, but in a situation like this, my lord, where you are selling off a property, or after you are, my lord, interpreting, my lord, a solemnama. The courts had to see that, and that is where the fraud comes in. And moment fraud comes in, my lord, my right to file a suit separately
Now
comes
the
in.
question is whether the court was misled or not.
Absolutely. Completely. Completely. My lord, they are not going away from the solemnama, nor am I.
That means according to the trial judge, the court was not misled.
Was not misled, but the
matter of records, whether
matter of record says something different.
whether court was misled or not.
Completely. My lord, the record of the courts show.
And that 72 was not complied on.
Never. Never. He cannot buy. 72 is a bar. 72, my lord, is a bar. Nothing beyond that. It's a bar on him. Then, my lord, if your lordship sees, now let me adjudicate the next question as raised by the learned counsel appearing on behalf of the appellant plaintiff, but whether non-service of notice to show cause upon the judgment debtor Dhirendranath Boiddo in connection with second execution case being censored would vitiate the said proceeding by practicing fraud upon the court as well as the judgment debtor. In order to adjudicate, he looks into Order 21, Rule 22, and then says 104, third line. No notice of show cause in respect of any execution
104?
case. Yes, Lord. 104 after Order 21, Rule 22 is set out. After a plain reading of the aforesaid provision of law, I have no hesitation but to opine that in view of Rule 22 of Order 21 of the Code of Civil Procedure, no notice of show cause in respect of any execution case was required to be served upon the judgment debtor if the execution case is filed within 2 years from the date of execution, as happened in the present execution cases. This is where they go on. This is where they go on. Need not trouble your lordship with the entire, comes down. Last line. I am of the considered view that it was not necessary to serve the show cause notice of the second money execution case number such upon the judgment debtor Dhirendranath Boiddo, and accordingly I am constrained to hold that no fraud was practiced by the degree holder. So he is adjudicating fraud. Ramchandra Mukhopadhyay, since deceased, as well as his son, as alleged in collusion and connivance with the process server, particularly such and such, was instituted within statutory period. The allegation of fraud made by the plaintiff appellants against the degree holder in connection with money suit number such and such, as well as his son Lokhi Prasad, is now under consideration. Now let me discuss as to what is fraud. Very important, Lord. This is what my case is on. A fraud is an act of deliberate deception with the design of securing something by taking unfair advantage of another. It is a deception in order to gain by another's loss. Stop here for a moment. Lord, put this finding into perspective in our case. What happens? Solemnama, first execution, dismissed on part satisfaction. You file the second execution within 20 days. Get the auction sale. Who buys it? The degree holder buys it. So is it not, beloved, that it is by deception that he is gaining something which is lawful to me? And sees, beloved, the series of facts which show, beloved, even the money which I owed is actually paid to one of his, beloved, successors. And that's an exhibit. Lordship looks at, takes this into perspective, puts this part and takes with respect to our factual situation. I read it for your lordship again. A fraud is an act of deliberate deception. Was it not deliberate of him, to file the second execution? May I ask this question to myself? deliberate deception, with the design of securing something by taking unfair advantage of another. Non-service of notice, unfair advantage. Nobody is there to, my lord, stop him. What happened in the first execution? There was nobody to buy. Kindly keeps that in mind. So, my lord, part satisfaction, 400 rupees. Part satisfaction.
That was dismissed.
So now what happens is, with the design of securing something by taking unfair advantage of another, I don't have notice, saying that it's 2 years. Then, my lord, it is a deception in order to gain by another's loss. He is getting 6.25 acres for 30,000 rupees. Bighas, not acres. I'm sorry. Bighas. So this is where, my lord, I am saying the court itself should have understood this fact, which is admitted. And put, my lord, this, what he has come to a finding, doesn't require, my lord, a proof. Doesn't require proof. Why? Because it's on record. It's on record. My lord, when is proof required? When, my lord, things are, there is a disputed question of fact. That's when evidence is required. Here, my lord, from the record, which is an exhibit, this fact comes out. And once there is fraud, everything vitiates. Everything is vitiated. Then, my lord, I want to finish it, my lord. In the suit on hand, the plaintiff appellants have pleaded in their plaint that the degree holder, Ramchandra, lordship need not trouble my lord self, comes down. Sees 107. Very important. Sees the second paragraph. It is also tried law that fraud is, however, inferred if the plaintiff succeeds to prove that there was not only statutory non-compliance detected in a proceeding, but also the plaintiff has to prove that he has sustained substantial injury by reason of such irregularity or fraud. Lord, what more injury, my lord, the learned judge was contemplating, my lord, I don't know, for your lordship's kind consideration. My property of 6.25 bighas is going off, my lord, with a lot of respect. If that's not injury, my lord, then what is, may I ask this question to myself? And that's my dwelling house. Along with, my lord, my business, my livelihood. This is where we are. And the Honorable, the learned judge is saying that I have to prove what is the injury. I don't think, my lord, the learned judge even looked into what the facts were in this case. Now we see as to whether the charge of fraud as alleged was actually occurred or not in the second execution. I would like to discuss one by one of the allegation of fraud taken in the pleading of the plaintiff appellant. Firstly, this signifies that my pleadings were, full of whatever the frauds were. So the learned judge is now coming to that. So Order 6, Rule 4 doesn't come into play at least.
Yes.
Firstly, the plaintiff appellants vividly alleged that no notice to show cause the second money execution case number Sansar was served upon judgment debtor Dhirendranath Boitu. Record reveals that the money suit number Sansar were degreed on Sansars. The second money execution was undisputedly filed on 27th of April 64. In view of Order 21, Rule 22, my lord, here what he did not record, the learned judge, was the dismissal of the first execution case and when the second execution case was filed. He says, my lord, 62 degree, 64, I have filed the second one. Are? What happened in between?
Whether all the facts were placed before the court.
Everything was, my lord, he's recorded those facts, my lord, in the earlier paragraphs. He records it in the earlier paragraphs. The last where it is necessary, where the decision making comes, he forgets that.
That is, one is with regard to the notice.
Yes,
which the learned
then
judge has
execution case
assigned with regard to the decision with regard to the period. Second is with regard to whether that execution case
was at all could have been filed on.
After it is dismissed.
After 21 days after it is dismissed. Within 21 days after dismissal. And then take advantage of Order 21, Rule 22, not served, sell it off. Who buys it? The degree holder. Correct. সেটা মাইনের আর্গুমেন্ট করবো তখন। Lord, may I come back on the next? I'll start from here.
Yes. Yes. So, Mr. Chair, yeah, with regard to facts, how long will you take next day?
It's almost over, my lord. Now it's on law.
So come ready with your decisions also.
It's that even today, my lord. But
The next day you start.
city of time, I'll start off with.
Learned advocates for the parties are present. Mr. Chatterjee submits but could not conclude the submissions. Let this matter appear for further hearing on.
যদি
16 তারিখ দেখুন, হ্যাঁ 14, হ্যাঁ okay, 21/9/2026 at 2 p.m.
না আর জজ সাহেবকে এ করবেন না।
So your learned friend is patiently waiting.
So that's why I said your lordship has
Learned junior friend
heard a lot of seconds.
patiently waiting.
Now, my lord, at this hour, my lord, your lordship need not trouble him.
Learned
comes back from the circuit, my lord.
learned advocate for the,
কি কোনোভাবে
yes, you are for the writ petitioner. Respondents are present.
আচ্ছা, state is
ও
present.
ডেকে নিয়ে চলে আসবে।
My lord fixes the date.
Learned advocates for the parties are present.
Respondent তো নাই নি
Okay, no time today. The matter stands
It's
adjourned.
assigned to
till-
your lordship, my lord. So
The matter stands adjourned to
চিটিং বাজি রেসপন্ডেন্ট দিনও
18 তারিখ হবে। ও
Well,
18 তারিখ শুক্রবার হচ্ছে। 17 21 তো কোটায়
my lord will be perhaps coming back from the circuit on 7th of September.
not 7th, it is on 9th, 8th or 9th
If it could be not kept.
next week. See, I've already fixed
No, I
matter.
won't take much time. I won't take
তারিখে
much
আছে
time.
কিছু?
কেন
14th September.
9th হবে না বলছে।
Okay, 21/9
Your lordship
2026.
keeps it on the day, my lord, with the second appeal.
No,
So 21/9 2026 at 12 p.m.
On 21st September, my lord, keeps it at 3:30.
No, হবেই না আমার মামলা। 12
হ্যাঁ ভালো হবে এই মামলাটা শুনবি বলো
21 তারিখ 12
ভালো লাগবে।
Grateful. 21 তারিখ 12 টা। 4:30